My lords, I beg to mention item 3 to 6. Jointly, we are mentioning this. Can this matter be taken up on 9th of April?
9th of
We
April,
have
my
not-
lord. In fact, I also have to file some other wakalatnamas as well, my lord. I appear in 3, 4, and 6, my lord.
Item 3,
4 and 6.
4, 5, and 6.
Yes, 5, my friend Mr. Parme appears. 6. Yes, yes.
Yes. All are requesting.
All.
Allow Kuru.
9th is what? Which date?
Thursday, my lord.
Thursday,
ठीक है से.
No, 9 is Monday.
April.
April.
Yes.
9th April. 9th April.
A joint prayer has been made by the learned council for both the sides in all these writ appeals for fixing the matter on 9th of April. The prayer is allowed. Let this matter be fixed on 9th of April.
Obliged, madam.
Deeply
I
obliged.
appear for the Airports Authority of India, Lord. I don't have any say on that. Only- They have agreed, but I have not.
But you also agreed.
No, sir.
No, I have no option, Lord. I am the respondent hearing. I cannot object to
Performer
us.
respondent.
Only thing is contempt is there, Lord. That was
He's a formal party, actually.
You are for
Airports Authority of India.
respondent number?
But I'm just giving the number, Lord. I'm only thing.
There are many respondents.
Well, Lordship, I record for
Judge.
Airports Authority of India.
Airports.
Joint prayer has been made except by respondent number.
Respondent Airport Authority of India.
Except by the council representing airport authorities. Remaining will remain same.
Obliged.
Deeply obliged.
Part 7.
7. Item number 7, Padhat matter.
You have produced.
Lordship, the yellow plague one, that is the document downloaded yesterday as per the order of the Sonal Court. And the pink one was the Lordship certified copy, which was placed before the Sonal Court at the time of Lordship hearing of the before the single bench, Lordship. The pink one. This is certified one.
So it was produced before single bench.
No, they could not place the certificate which is required to be.
Okay, otherwise the copy was produced.
Certified was copy. It
What
is
is the
reflected
copy?
in the
Hello,
judgment also, Lord.
Whatever it may be, my lord, I have the instruction from my client that he lost confidence on me. Therefore, my only choice is to retire from this case. I am not going to make any other argument. That is my lord, the instruction I got. Even I wanted to go tomorrow, yesterday itself. But since I assured your lordship that I will appear, that's the reason I'm appearing. Otherwise, I don't have any interest in this case.
No, you have instruction not clear.
My lord, it seems the conversation, the interaction which I have with him, he lost confidence on me, and I thought it is better not
But
to
you
appear.
have
Already argued.
argued the matter.
Yes,
substantially.
that's true. But then there are so many things, other things are there. But in such a scenario, my lord, it won't be fair on my part.
What
because-
scenario?
My lord, the way he was talking to me, it was not a very palatable one. And even I wanted to leave yesterday itself, but then since my assurance was there, I'll be appearing today. That's the reason I stayed back. And just to inform your lordship, that's on my part, under such a factual scenario, It will not be fair on my part to appear and argue once again.
No, otherwise we have heard you substantially.
No, that's true, my lord.
You
But
only submitted that some citation, you will be relying on certain.
yes, certain citation, apart from that, what will be the effect of he has submitted certain things which are not part of the record. Therefore, under that circumstance, what is the position of law? Now, let him engage some other advocate of his choice. Let him do that.
No, but we cannot appreciate this approach.
No, that's, but so far I am concerned, the lordship kindly consider my position. If someone says something which is beyond the dignity of the profession, should your lordship will ask me that, no, you'll have to argue.
No, we are not on that.
That's the question so far I am concerned.
Actually, we are on the issue that we have already heard you substantially.
Yes, yes, that's,
At this stage,
but the
even
stage is different because when somebody says something, then on my part, I think it's really embarrassing. And during my 43 years of my professional career, this is the first time I have encountered such a thing. And therefore, my lord, at least I am not going to appear any further.
Then I have no objection under these circumstances.
Only because I assured your lordships, I'll be appearing tomorrow. I stayed back. And my lord, just to inform your lordship, this is the position.
Subject to lordship's convenience.
Otherwise, as a lawyer, my lord, we come for this. I was fully prepared and I have come for the purpose. And we enjoy doing that, my lord.
You said like something remained, I mean.
Yes,
We
yes.
wanted to,
My lord.
but we heard you substantially. I mean, all the points like you wanted to argue.
No, there are some other points, my lord.
Already you have placed.
The constitutional points are also there, my lord. I wanted to highlight it, but
So
we-
what is your submission? The respondent intends to engage some other.
it's up to them, my lord. It's their prerogative. They may engage some other counsel, but for me, it's really sheer amount of embarrassment.
No, if they want to engage,
They should have engaged.
they should have engaged today itself.
That is up to my client, my lord. I don't have any say to that.
No, I mean, we do not appreciate the behavior of the client. So I mean, we may go ahead with the.
Yeah, that's up to your lordship's prerogative, my lord. I don't have anything to say there. But then, my lord, whenever any such thing occurs,
Okay,
usually, my lord, your lordship will give them time to engage their own counsel because they should not be seen to be unrepresented.
no, actually, the situation is that we have substantially heard
Yes, that's true.
yesterday, the entire first half.
Yes, there are no quarrel about that. So far, I am
I
concerned.
mean, if he's in a different mind, then he could have sent somebody today. I mean, rather than sending you, I mean, he could have sent somebody, engaged somebody, he could have, I mean.
My lord, to that, I do not have any say, my lord. Yes.
Yes, there are. We are giving some time. We are fixing it day after tomorrow.
My lord, that's
So-
all. I don't have any say so far that is concerned.
No, but
I can only inform him this is the position.
Yeah, so please give it, we are fixing it as a first item on the.
Yes, yes.
And we'll conclude it on that.
Go.
Because we have already heard both the
Go.
parties, only maybe some portions was not argued.
So far that is concerned, I don't have any say. I'm just retiring from the case.
heard. Mr. S. Tapin, learned senior government advocate appearing for the appellants. Also at Mr. S. Datta, learned senior counsel assisted by Mr. T. Kapche, learned counsel for the sole respondent. Though yesterday the matter was substantially heard and the learned senior government advocate was directed to produce the original note sheets supported by necessary certificates under section 65B of the Evidence Act, which has been done by the learned senior government counsel, however, learned senior counsel for the sole respondent submits that the whether the client don't want to or you don't want to,
I don't want.
that he do not intend to represent the respondent any further owing to some misunderstanding between him and the misunderstanding between him and the respondent. He submits that though yesterday he submitted before the court that he would be citing certain decisions on which he would be in support of his submissions, however, in view of the recent development, he want to withdraw from the case. Considering the submissions made by learned senior counsel for the respondent, we are of the opinion that since the matter has been substantially heard, the respondent may be given an opportunity to engage a new set of counsel in view of withdrawal of wakalatnama by learned senior counsel S. Datta. He may do so before the next date of hearing. List this matter again on Thursday, that is 5th of March, as yes. Remove the sentence withdrawal of wakalatnama. You are there.
No, he has just come with me today because.
No, entire set of counsel.
Yes. Enter, my lord, I can say about me and my junior, Mr. Siddhant Datta.
Because, I mean, you don't fight a wakalatnama, so somebody.
No, Siddhant, yes,
Who has signed a wakalatnama? Anybody is there? in the court?
that is Gamkin, no? One Mr. Gamkin.
Gamkin is there or not?
Yes, he is not present today. But let your lordship may say, so far I am concerned, I am withdrawing from the case.
Yes. What was the last line? Let this matter be listed again on 5th of March
Yes,
as part heard matter.
right. Obliged.
Lordship may observe one thing, Lordship, my senior friend would inform the client accordingly. Lordship.
No, that is obvious. These are all a video recorded conference. Nobody can deny all that.
No, you have a duty to inform.
Definitely, my lord.
That's the
Definitely, it's my duty. I will convey
Learned
that.
senior counsel undertakes to communicate this order to the respondent today itself.
Yes. That's my duty, my lord. I'll perform my duty.
So this record will be retained with
Retain the record till next date of.
close
Publish.
of like.
Item number 1 and 2.
That will remain there.
Not place, Lord. Well, by the impugned, my lord, judgment, my lord, partly allowed my writ petition, and partly, my lord, the prayer sought for has been denied. Now, Lordship will find the impugned judgment is
No,
at page 530.
Whether these appeals are admitted.
My lord,
No,
by the last
not
order, as well as then order of the earlier occasion, the matter was fixed for disposal at the admission stage. That is 22/1/2026.
22/1.
2026. And also on 22/10/2025, two orders.
For hearing the appeal, we have to admit it.
But the issue is because the issue is very in a narrow campus and there are urgency in the matter, my lord. But since your lordship desires to hear only after admitting, lordship may.
No, we can admit it today and hear it today also, but I was only questioning the procedure which is followed.
For both way, my lord, at the admission stage also it can be disposed of, and after admitting, then also, my lord, it can be done. Yes. It can be even disposed of at the motion stage also, my lord, depending the agreement of the parties as well, my lord. Only to be, my lord, whether a lengthy, my lord, hearing would require. That is the issue, my lord. While it is admitted and heard, my lord, sufficient time has been granted to the parties concerned. Now at the admission stage, limited prayer and limited argument. And here also I am on a limited prayer and limited argument. Out of the three, my lord, direction, two are in my favor and one is against me.
Yes. Okay.
And so lordship feels that
How much time will you take?
maximum, my lord, 15 to 20 minutes perhaps, my lord.
And Mr. Kato?
Kato is smiling. Why?
My lord, my submission would be also, my lord, on limited issue, my lord. It's because, my lord, at the very outset, my lord, my submission would be this is not maintainable at all, my lord. It's because, my lord, the barrier which has been sought for by the, my lord, the FLN has already been considered in by the learned single bench, my lord. So therefore, my lord, that is the only issue, my lord, which I will be raising, my lord.
Okay, let us hear. Yes.
Now, my lord, thus to highlight the, my lord, the points, my lord, your lordship will find the judgment is at page 530. And the direction that has been given at paragraph 24, page 544.
530.
So the issue only remained with the bank guarantee,
My lord,
performance bank guarantee, right?
not exactly on the bank guarantee.
Then
My lord, two issues were there, whether, my lord, the third party can be bound by the contract or an agreement entered between the parties where the third party is not at all a party.
third party is the bank,
No, third party is myself.
yourself.
The contract was entered between the, my lord, the authority, BRO, Border Road Organization,
No,
and the
Mr.
one
Saikia,
village.
tell us the gist first.
Yes, yes.
Brief gist of
Yes,
the
yes.
matter.
Madam, why I'm just bringing your lordship to page 544. The three, my lord, direction has been given. The first I am satisfied. I have no, my lord, grievance against that. Page 544, paragraph 24.
The direction which relegate you to civil court.
Yes, that's the only two. And the third, all pending bills, if not paid in the meantime, shall be released in favor of the petitioner in terms of joint verification. But that is exactly, my lord, in my favor. First is in my favor. These two, my lord, liquidated damage, etc., etc. These are governed by a contract agreement between the Border Road Organization and the Valecha, that is the principal contractor. I don't have any agreement either with the Border Road Organization or with the respondent number 6, that is the Valecha Engineering. Only document what is there is the approval by the BRO, Border Road Organization, allowing me to perform as a subcontractor to the extent of 49%, my lord. That approval, your lordship will find at page 88.
No, bank guarantee which was deposited by 6, respondent number 6,
Lordship,
was paid by you.
was paid by me.
That is the issue.
That is one of the issue. That is with regard to the release of the, my lord, bank guarantee. The documents are here to show that the bank has said that the bank guarantee was prepared by me, from my account, my money. And I'll come to the background of the, my lord, the case, my lord. I'm just the document what is, my lord, available so far as in writing between me and the BRO or the, my lord, principal contractor is at page 88.
Yes,
Relevant, lordship, may come to page 89,
just a minute.
paragraph 3. From paragraph 2, please refer to above letter requisition therewith the approval of Messrs. Petro Dumpen Enterprise as subcontractor 49% value of contract, that is 33 crores 23 and so and so. The proposal has been examined in the light of provision under clause number 4.2 of EPC agreement under contract agreement number so and so. The proposal submitted by a firm to allow Messrs. Petro Dumpen Enterprise B sector so and so to execute the subcontract work as subcontractor is in principle agreed for the subject work to the condition that subcontractor shall not be allowed to execute the work more than 49% value of the project. However, the EPC contractor, Messrs. Valecha Engineering Limited, shall at all times be responsible and liable for all its obligations under the contract. So all the responsibilities and, my lord, liabilities are still, my lord, remain with the Valecha. And my condition is that I cannot execute more than 49%. If I do any work, my lord, substandard, or if I don't do any work, anything is, my lord, damage or, my lord, collateral damage, whatever, my lord, is required to be, my lord, the person responsible would be the principal contractor, not me, my lord. Now, coming to the facts, my lord.
Yes, yes.
My lord, pursuant to the tender notice, my lord, the LOA was issued to the Valecha Engineering Limited, who was a, my lord, private respondent number 6 in the.
He is the EPC contractor.
Is a EPC contractor. He was the principal contractor. There is an understanding between him and me that if he gets the work, then he'll allow me to execute the work 100% back-to-back basis
What is your scope of work?
as a subcontractor.
The scope of work is what?
Yes, well, that was the understanding with the Valecha, but then after entering into the contract agreement,
You'll be a supplier, you'll be a construction contractor, what?
construction contractor.
Construction contractor.
Yes, my lord. At the same, my lord, shoes out of the, my lord, the principal contractor, EPC contractor, I'll be doing, my lord. To the
You
extent,
have a separate contract with the EPC contractor.
there's only one contract with the BRO and the EPC contractor. I am a subcontractor.
No, no, what are your terms and conditions with the contractor, EPC contractor?
I don't have any terms, sir. I don't have any, my lord, agreement with him, my lord. I don't have any subcontract agreement or any agreement with him. It is only the letter that is approval, letter that I have, my lord, shown, my lord.
So then you don't know which is the scope of work of yours.
Well, because principal contractor is there, I'll be
In all
lodging,
EPC contracts,
Lodging.
EPC contract is the principal contractor.
principal contractor.
And he subcontracts many work because he may not be able to fulfill all the,
Exactly,
scope of the work.
lodging,
So he obviously, he gets specialized people for
Right.
specialized works.
lodging,
So maybe like he has got you.
lodging.
But usually what happens is the EPC contract usually have a contract with the subcontractor.
Exactly.
These terms and conditions are laid down there. So whether
Exactly.
you have any contract or not, because those
No.
terms and conditions will say whether a bank guarantee will be given by whom, how it will be done, all these things will be termed there.
Lodging.
It should have been documented there. Whether
Lodging.
there is any document with you. or not.
Nothing, my lord.
You don't have any document.
There's no document. But
Okay.
fact remains that, as my lord, I said, my lord, prior to submission of the tender, there is an understanding that if the work
That,
is,
that happens in
lot.
every contract. That happens
So
in
the-
every contract.
so the-
big, I mean, like with, finance is big, scope of work is big, EPC contract is engaged, then EPC
Right.
contract engages many contracts.
lodging, my lord.
So, but you don't have a document. I mean,
Document.
with the.
Document, I have stated in my writ petition that soon, my lord, this approval was only to the extent of 49%. I have approached the authority. I said that you refund me the,
49% is very vague, isn't it? I mean, which 49%, I mean, how you are going to calculate 14%?
well, it is always in terms of the, my lord, amount, my lord, the price, my lord. 49% always, my lord,
Okay,
judge
okay,
in
okay.
terms of the, my lord, amount, my lord.
Okay.
Now, so far as, my lord, your lordship will find, my lord, paragraph 10 of my writ petition.
Page number,
Lordship. Page number 55, my lord. Paragraph 10. May I read?
yes.
The petitioner states that it has submitted the bank guarantee to the extent of 2,3,49,000 as per the MOU executed between the petitioner and the respondent number 6 on a clear understanding that the petitioner will be allowed to execute the entire work on back-to-back basis, and was absolutely in dark as to the clauses in the contract agreement that the respondent number 6 cannot subcontract more than 49% of the said work. Therefore, on receipt of the aforesaid letter dated 7/10/2021, the petitioner intended to withdraw the aforesaid bank guarantee with the permission to resubmit proportionate bank guarantee to the extent of the work approved. However, the respondent authority denied said request on the ground that such request can only be accepted after subcontractor completes the approved work. But this statement has not been, my lord, denied by the respondent authorities in the affidavit in opposition. 209 is there, my lord, affidavit in opposition.
But one thing very silly, I mean, this letter, I mean, page 88, it was given to you also?
Page
88, that the letter you have shown, this, just now? That 49%,
Lodge, yes, yes,
it was given to you?
yes, yes. It was copied to me, my lord, page 90, my lord.
So, I mean, if it is given to you, you were
Yes.
aware?
I am aware of this letter, so therefore on receipt of this letter, I wanted to withdraw the.
No, correct.
Lordship. My lord, in the page 88 or 89, my lord, the copy too has not been typed properly, but the original of the photostat of the original is at page 90. Lordship will kindly come to below. Copy to Petro Dumpen Enterprise.
No, and where is your MOU?
MOU is not annexed because it has nothing to do because that was for the purpose of submission of the NIT.
Correct. We wanted to see, I mean, what was there in the MOU? I
Lakshmi.
mean, what are the terms there? I
Lakshmi.
mean, whether you were aware of.
In
49% or not?
yes, yeah, they have annexed, but then my lord, even in the affidavit in opposition, they have said this MOU has no value, no evidentiary value, nothing. That is nothing to do with my lord, the BRO. And it is in fact, my lord, they have, you will find it at page 499.
The MOU was executed when?
It was executed 13th day of October 2020.
13th of?
13 October 2020.
Okay.
LOA was issued in favor of Valecha on 22 to 2021.
So what happened after that? You wanted to withdraw, but you were not allowed.
Withdraw, they said unless you complete your work, will not be allowed to withdraw. Only once you complete. And this has not been denied in their affidavit also, my lord. And they have also said whatever you have understanding, it has nothing to do with the instant contract, my lord. Now what happened? I have continued the my lord, execution of the work. Now, as per the condition of the my lord, BRO, we had to operate a escrow account. So that escrow account was my lord, opened. The amount were deposited in the escrow account, and thereafter that amount was supposed to go to the my lord, a certain amount to the my lord, 3% to the my lord, the principal contractor, remaining to the my lord, the subcontractor. But then the amount goes, he did not pay to us.
The escrow account is as per the contract.
It is not as per the contract. It is because the subcontract
Is
is
there
there.
any provision of escrow account in your contract? I mean, in the principal contract?
My lord, I have a doubt that there is no such. My lord,
So there has to be, I mean, there has to be a provision of an escrow account in the principal contract.
I'll check up. I'll let you know, my lord. Then, my lord, I complained to the my lord, authority that I have been executing work. He is not paying the amount for which the delay has been caused, and the work has been hampered. After repeated requests, they have exercised their power under the contract agreement. They have directed them that you pay the amount to the subcontractor. But in fact, they should have, my lord, given the amount directly to me, knowing fully well that no portion of the work has been executed by him, by the principal contractor. They did not do so, my lord. And ultimately, I have continued the work. But because as per the milestone, the work was not my lord, to the extent of the milestone. So therefore, notice of my lord, intention of termination was issued to the my lord, principal contractor.
Not to you.
Not to me. Not to me. I am continuing. He is not working anything.
You are continuing on your own risk.
No, I am not on my own risk because of the letter approved, my lord. My lord, this is the
49%.
my lord.
49%.
49%. Had there been any default on his part, they could have easily said, "Don't execute." They have received my work.
No, this is only allowing the EPC contractor to subcontract. And that too, till 49% you can subcontract. Because you being an EPC contractor, so we are giving you a right to subcontract it, but
Gotcha.
till 49% you can do it.
Yes, but all the responsibility will remain with the principal contractor.
Absolutely.
Absolutely.
So I mean, whatever the liabilities will be the principal contractor.
Principal contractor.
That is there.
That,
Now thing is that like, so the money, I mean, execution or whatever, I mean, liability will be obviously with the principal contractor. But you will be liable to the principal contractor. Correct. You will be liable to the principal contractor in terms of your agreement with the principal contractor.
but I don't have.
You don't have any agreement. That is the problem.
I don't
I
have.
do not. Now,
Had I, matlab, if I
the
would have.
problem is that I mean now I'm finding it very difficult to understand that without having an agreement, how you are performing the work. with
Matlab,
the subcontractor.
That is the matlab, approval letter. It is clearly matlab, said.
Approval letter only to engage the subcontractor, not more than that. It happens in all EPC contracts.
Right.
All EPC contracts it happens. They have listed subcontractors sometimes, or otherwise the contractor brings in a subcontractor. Then that subcontractor is being approved by the employer, and approval will be given to certain, I mean, with some limits. Maybe the percentage of the work, maybe the scope of the work, looking into his credibility and this thing. Then subcontractor will have a contract with the EPC contractor, having his terms and conditions. But in this contract, I don't know why there is no agreement at all.
Exactly, my lord. Normally what happened is subcontract agreement also, my lord, has to be, my lord, submitted to the, my lord, principal contractor and the, my lord, to the employer, and employer
Now
approves it.
you are saying that the issue only remains is that like you are saying that like you have given the bank guarantee.
That is one aspect, my lord.
Mm.
My whole case is that I have executed the work legally by an authority of the, my lord, the BRO. They have allowed me to work, and I have legally executed the work. And I executed the work not for any other gratuitous, my lord, reason, but bona fide that
In your contract, I mean, who is supposed to give the performance bank guarantee?
Principal contractor, madam.
Principal contractor.
Yes,
Why did you accept a bank guarantee given by a subcontractor?
Malad, as per the record, this bank guarantee has been furnished by the principal contractor. Though it may be it is their internal matter. We don't know who has deposited the cash amount. But then the amount which has been deposited with the authorities is in the name of the principal contractor. So therefore, on record also, it is in favor of the authorities by the principal contractor, respondent number 6 only.
Okay.
Yes.
now, my lord, soon the notice of, my lord, intention of termination was issued. My lord, I apprehended that all my money will be, my lord, would not be, my lord, paid to me. Even the liquidated damage, etc., will be imposed on me. I have submitted, my lord, representation that you should not be doing, because it is me I am working. It is not the principal contractor who has, my lord, executed any portion of the work. That finding is, my lord, admitted by them also, my lord. I'll show to your lordship, my lord. They did not, my lord, oblige to it. Ultimately, the work has been terminated. So I have approached this honorable court. Now, considering the, my lord, situation of the, my lord, bank guarantee, that the amount was
LD was imposed by whom on whom?
now from my bill, the bill which I am to receive, therefrom they have, my lord, deducted the LD and the damages, all these things. That is the, my lord, issue, my lord. Honorable single judge has, my lord, clearly, my lord, directed that all pending bill to be, my lord, issued to the, my lord, present
You were
petitioner.
I mean, you were not directly paid any bill by the DRO.
Not earlier. It was, my lord,
Because there is an escrow account.
there was an escrow account.
So from the escrow account you get it, your share.
Yes, sir. But that amount I did not get. So
LD imposed by whom? LD imposed by
by BRO
on you.
on my bill. This court has directed me to pay the bill, so they have, my lord, imposed all the LDs, everything from me. So therefore, the question arises, my lord, the contract which subsists between the, my lord, BRO and the, my lord, Velacha, could those terms and conditions be imposed on me, my lord? Deduction of it, because they are, my lord, mighty and giant, my lord, organization. They can have different, my lord, things, but these are the local contractors, my lord, based on their, my lord, little experience. They go for, my lord, execution of subcontract to the extent of 5%, 10%, 20%, whatever, my lord. Now here is in the, my lord, 49%.
No, you are doing 49%.
Lord,
So it's a huge chunk of work.
For that, my lord, I have to, my lord, finance, my lord, borrowing, my lord, from different institutions, different things, my lord. I have to, my lord, gain, my lord.
That's your problem.
No, that is exactly, that is my problem. But then this court is also, my lord, here to, my lord, see the
The court will go by the
State
terms
of-
and conditions.
yes, my lord. So there is no terms and condition, my lord. There's no terms and condition. They cannot show anything that in case, my lord, the principal contractor fails to pay the damage, it will be realized from the bill of the subcontractor. There's no such, my lord, condition. Now, therefore, that question has arises whether, my lord, the third party can be, my lord, imposed with the condition of a contract or an agreement which was never entered with him. That is one condition, my lord. And second aspect, my lord, taking recourse to the section 70 of the, my lord, Contract Act. This court has, Honorable Single Judge, accepted that proposition and have directed them that all the pending bill you pay to the subcontractor directly. That is because of the, my lord, provision of section 70. If I am, my lord, permitted to take to the, my lord, section 70.
Contract Act.
Which is the main contract? You have the main contract.
Main contract has not been, I don't have that contract, my lord. That is with them, my lord.
You don't have the main contract.
I don't have them.
So you don't know the terms and conditions of the main contract. The contract entered by the EPC contract with the the employer.
Lord, my lord.
You don't have the contract.
But contract as such, I don't have, but I know the different
No, I
terms
mean,
and conditions.
terms and
It has not been annexed here too, but so far as, my lord, the relevant clause of, my lord, that is clause 4. Clause 4, I have, my lord, quoted also, and they have also annexed that portion of the, my lord, contract agreement. I have, my lord, clause 4, I have mentioned at page 51.
Yes.
Sorry, Manoj, I said the copy is not available. Copy is there.
Okay.
Yes. Your Lordship, we just looked into it.
There is a MOU also, internal understanding, Valecha and Petro Dumpam.
Lordship.
That MOU is there,
Yes, that
Yes, okay.
MOU has been annexed, Manoj.
228.
Yes.
Yes, this is 229, Your Lordship will find. Fifth paragraph from top. And whereas Valecha and PDE, that is present appellant, have decided to quote jointly for the project in the name of Valecha, and if the work is awarded to Valecha, in that case, the same will be subcontracted to PDE by Valecha back to back under following terms and conditions, the so and so, which also includes deposition of the entire bank guarantee, my lord. So back to back of the entire, my lord, work. But here, as per the contract agreement, clause number 4, the contract cannot be, subcontract cannot be more than 49%. So therefore, I immediately on receipt of that approval up to the extent of 49%, I have approached the authority, said since the extent of work is only to the 49%, so I may be allowed to withdraw the bank guarantee and deposit the amount which is equivalent for the 49%. But they said, unless you complete the work, this cannot be, this may not be not allowed to be withdrawn. So I continued to work. And existence of this particular MOU has also been denied by them. They said it has nothing to do with us by the affidavit of the respondent, my lord.
No, that was a contract between you and the principal contractor, respondent number 6.
Lordship,
They are right when they say that it has nothing to do with them.
Lordship.
Now, the single judge has allowed you to get the money to the extent the work which you have done
Done.
after proper verification.
Yes, directly to me.
Now, the question that you have paid the bank guarantee on behalf of respondent number 6, that is a question of fact. Because on paper, it is the respondent number 6 who has deposited the bank guarantee.
My lord,
So,
my lord, two of the documents, my lord.
our query is where the single judge has erred in relegating you to civil court.
Lordship. My lord,
It has
firstly,
not closed your remedy.
no,
It
that
has
is true.
only
That is true, my lord. My lord, first, my lord, page 79, your lordship will kindly see, my lord. That is the bank guarantee, my lord. Page 79.
Yes.
Page 79, serial number 7. At the request of Petro Dumpam, that is present appellant, we hereby amend above mentioned bank guarantee as follows. Then page 81. It is confirming that the above mentioned BG has been issued from the account of Messrs. Petro Dumpam Enterprise, which was issued for Valecha Engineering Limited for construction and upgradation of so-and-so and existing so-and-so. So it is from my money, it has been made in the name of Velecha because contract is in the name of Velecha, so the bank guarantee has to be in the name of Velecha. But the entire amount deposited by me, and that was on the my lord belief that the 100% work would be allowed to be executed back-to-back basis. Now only 49% has been given. Now, so far as bank guarantee in a
It's
separate,
already invoked. Bank guarantee invoked.
Yes.
there is a stay order from this honorable court after the judgment that has been.
After invocation.
After in
No, my lord. It was not invoked.
Before invocation. Stay order cannot be, I mean, after invocation of the bank guarantee.
my lord, after invocation, my lord,
It was not encashed.
by that time, my lord, that has already been perpetrated. Bank guarantee, which has been deposited with the authorities, has already been perpetrated before
Bank guarantee already invoked and encashed.
yes, my lord.
No, that is after the judgment. There is a stay order from this court
Initially.
initially. There is a stay order. They had also filed an application for minor modification of that order so that they can encash it. But that was not my lord, taken to my lord, no order was passed on that. Finally, the writ petition was heard, and after having disposal,
Then
they have my lord, forfeited the amount. Now, so far as the finding of the bank guarantee is concerned, that is in a separately honorable single judge has my lord, come to that finding, my lord. At page, let's say we'll find. Page 542, paragraph 19.
So as far as now, since bank guarantee is invoked and encashed, so you don't have any I mean case against them now. As far as the bank guarantee is concerned, the bank guarantee is something. There's an agreement between bank and you.
No, that is all right. But whether, my lord, that amount having been deposited by me,
No, that cannot be. I mean, now hesitated here.
that of course, my lord, I may have to go to the, my lord, civil court.
See, he doesn't have anything to do with this. Bank guarantee is a separate agreement altogether.
That is
It's a separate agreement.
Lordship.
So if you have any grievances, then you have to, I mean, you have to make the bank party and like you have to sue them that you have wrongfully allowed them to invoke the bank guarantee.
The bank was party in the writ petition.
Correct. So
The
here it
bank was
cannot
party.
hesitate that.
Now having been, my lord, but then the finding your lordship will find in the paragraph 19. Though it is contended by the petitioner that they have furnished the bank guarantee, yet the record speaks otherwise. Therefore, submission of Cycle and Council for the left this court unimpressed. However, it appears to be disputed question, but in what mentioned that context, while exercising the court is not entitled to adjudicate this dispute. But then the documents 79 and 81 I have shown, my lord, this amount by which the bank guarantee was, my lord, prepared, it was my money. No, now whether, my lord, that may lordship may, my lord, allow me to, my lord, hesitate before the, my lord, civil court. That is another thing, my lord. But the others, so far as the issue of liquidated damage compensation, this is not a part of, my lord, any agreement
See,
with.
this contract is actually performed in a different way. Contract is actually you have become sort of a main contractor only by virtue of this letter 49%. Because I mean you are executing the work. 49% you are executing the work. It's not that I mean you are not executing. So if a milestone is not met, who will be made liable?
It's clearly mentioned. It is the Velacha will be made liable. The letter itself speaks all the responsibility.
That's why I'm asking whether you have any agreement with Velacha. You don't have any agreement with.
We don't have any agreement.
So you don't have.
Had there
So
been,
basically, you have gone into the shoes of the main contractor in performing the contract, rather than working as a subcontractor.
my lord,
For 49%.
my lord, if that the proposition goes, my lord, in that case, my lord, this section 70, my lord, would not have come into, my lord, play. My lord, if
70 is in a different context.
my lord, if there be any agreement with any person, then section 70 cannot be, my lord, invoked because it will be governed by the agreement. But only requirement is that, Lordship, may kindly, that's what my lord, I wanted your Lordship to take into the section 70, my lord.
Yes.
Whether I have executed the work legally. That is first condition, my lord. Section 70,
Yes.
obligation of person enjoying benefit of non-gratuitous act. Where person lawfully does anything for another person or delivers anything to him, not intending to do so gratuitously, and such other person enjoy the benefit thereof, the latter is bound to make compensation to the former in respect of or to restore the things so done or delivered.
So
Now,
whether
firstly,
this court will have jurisdiction on this
but that has
71,
70.
whether this court can decide on 71.
No, this is section 70, my lord. Is a my lord, law, my lord, that your Lordship will interpret.
I mean, this is a fact finding, this issue, this section 70, basically is an issue involving fact finding.
No, but here
The
I am, my lord,
fact-finding can be
I am showing the documents by which,
Those two documents will not be sufficient.
no, that will be your Lordship's satisfaction or dissatisfaction on the documents. But what I am trying to impress upon your Lordship is that I have executed the work legally. That is the approval letter. Had there been no approval letter, I could not have executed the work. Now, second condition is that whether I have done the, my lord, the work gratuitously, my lord. It's not that I have invested money, I have carried out.
And that is why single judge has directed that a joint verification should be made, and whatever money you supposed to get, it should be paid. That direction has been given.
So therefore I said, my lord,
That direction has been given.
that third direction, my lord, relates to section 70.
And as far as the damage is, now you are saying, as if you are saying that, like, okay, I have performed the work, pay me the money, but if I have delayed something or there is some kind of performance problem, then if LD has to be given, then LD I will not pay. LD other guy will pay. You'll take the money, but you will not pay the LD.
No, no,
Is this your proposition?
No, it is not my proposition. It is not on the records also.
No,
The record clearly
No,
reveals.
whether it is your proposition. Now you are saying I have performed the contract, fine, correct. You have performed the contract, then single judges, honorable single judges rightly said, joint verification should be made. Whatever work you have done, it should be paid.
Right.
That is correct.
Correct.
Now you are saying, now in performance of the contract, if there are some problems, whether it's a milestone or whether it's a performance based, if LD has to be, put on, then LD, you cannot put the LD on me. LD has to go to the other person because the contract one was in his name. That is your argument?
My lord, that is the purport of the letter of approval, my lord.
No, you don't have any case, Mr. Saikya. If you have any issues, then you'll have to go to the civil court.
Well, in that case, my lord, any third party can be, my lord, bound by the, my lord, agreement.
It's not a third party thing. I mean, it's apparently third party is already involved.
But where is, my lord, at least I don't find any agreement, my lord, with my agreement with the BRO. I don't find any my agreement, my lord, with the
You are
principal
yourself saying,
contract.
I have executed the work, 49% approval has been given by.
Yes, so therefore, my lord, I have executed the work legally.
Now you have executed the work legally.
Legally, so I am entitled to the amount.
But if there is a problem in the performance, you are not going to give the LD. Why?
Lordship will, my
You
lord,
pay LD for the 49%.
my lord, it is not the case of the respondent. It is not the case of the respondent that the sub.
Don't say that like, I mean.
No. It is not the case of the respondent that I have defaulted. It is the principal contractor has defaulted. He has to execute 51% of the work. I have done my 49% of the work.
But LD is on the whole contract or
They are trying to, my lord, impose in that way, my lord, just because, my lord, the remaining portion of the work could not be done by the principal contractor and I have executed, so I have been victimized and my amount has been deducted. That's what they are doing even in the term.
where is there LD, there's letter later?
My lord?
That the LD is imposed on you, where is that letter?
Well, there is no letter, my lord. After the joint verification, they have found, my lord, that something, my lord, 11 or 13 crores I received for the work I have executed. And thereafter deducted, my lord, something about, my lord, 3 crores and all, as LD imposed, etc.
No, now, what is your proposition? I mean, LD is on the whole amount or LD is on the amount that you have received and on your performance problem?
Malad,
No,
it
you
is,
have- you have-
as it appears, Malad, it is for the entire work.
As it appears, no, I mean, like you say firmly, no, that like the LD is imposed on the whole contract, not only the portion of your work.
No, it is for the whole contract because, my lord, I have performed my work, my lord. I have done my 49%. There could not have been
LD is imposed on 49% or the whole 100% of the work.
whole 100%, my lord. Yeah.
That you show any material on that.
Well, that is the only, my lord, the letter by which they have paid me the amount.
Where is the
Where
letter?
is that letter?
It will be page 4. My lord will find.
So you have completed the 49% of your.
Yes, yes, my lord. Available
49%
disposal of work,
public
my lord, I have. My lord, they are reiterating that I have done only 26.1, but that is of April 23. And subsequently, pursuant to the order of this court, a joint verification was done. And there, my lord, as per that valuation, my calculation comes to about 17 crores. There, according to them, it comes to about, my lord, 11 crores and odd. So, my lord,
Ultimately, your parties you have completed.
yes, well, more than that, my lord, I have completed.
Yeah, because you have completed, that's why the single judge has directed that joint verification should be made, you should pay.
Done, and I should be paid.
Correct. Now, you show me the letter where the LD, how LD has been imposed.
My lord, at page 525, 524, this is unsigned, undocumented submitted by them.
524.
It is unsigned, my lord, not addressed to anybody, but they have annexed with the affidavit in opposition that according to them, the valuation comes to this.
$524.
Deduction, lordship will find, my lord, serial number 6. Serial number 7, deduction on account of milestone number 2, April to so-and-so, 6 crores. The deduction for non-submission of royalty charges
This is
is,
maximum 10% of CA as per clause 10.3.3. Where is 10.3.3? Which is clause 10.3.3? So LD will be maximum 10% of the contract amount. As per clause 3.3.
yes. Because the entire contract amount is 67 crores 83 lakhs. So 10% comes to, my lord, 6 crores 78 lakhs.
See now how the contract, lays down about LD. How LD will be imposed? LD will be imposed, it's a weekly delay, it's a performance related issue. What is there? We'll have to see there. This figure that they have come,
How it was
6 crores 78 lakhs, how they have come up?
But this is 10% of the total amount, my lord,
Total amount of which contract? 49%?
principal, yes.
49 or?
No, total. Total amount contract price is 67 crores 83 lakhs. So 10% comes to 6 crores 78 lakhs, my lord.
This is a
And my work was to the extent of 33 crores, 49%.
That's why we wanted to understand.
That's it.
How they have imposed the LD. Now the Mr. Kato has to answer how they have imposed this 10% on you only. Because your contract value is 49%.
No, 10.3, may I read, my lord? 10.3.
Yes.
The authority shall notify the contractor of its decision to impose damage in pursuance with provisions of this clause 10.3, provided that no deduction on account of damages shall be affected by the authority without notifying the contractor of its decision to impose the damages, and taking into consideration the representation, if any, made by the contractor within 20 days of such notice, the parties expressly agrees that the total amount of damage under clause 10.3.2 shall not exceed 10% of the contract price. So that's how, my lord,
So that's.
No, that is the outer limit.
there's the outer limit. There are other procedure also that there should be a notice, then there will be
So
reply
the-
response.
these, I mean, see, now as far as this LD is
Now,
concerned.
my whole question, whether these clauses can be at all, my lord, imposed on me, my lord. And why, my lord, the person who has not done, lordship will kindly see, my lord, in the termination order itself, it is clearly reveals that up to April, what is their finding is
No,
that
if it is not applicable to you, then
Gotcha.
how you are performing the contract? On what terms and conditions you are performing the contract then?
my lord, under
If you
the
are saying that like
Gotcha.
this contract is not binding on you,
lordship, my lord.
then how you are performing the contract?
Well, under the guidance of the, my lord, principal contractor, therefore the responsibility is, my lord, levied on the principal contractor. The drawing, designing, etc., those will be submitted by the, my lord, principal contractor. The milestone, everything will be set up with the principal contractor. I have to execute. And I have been
But you
executing.
don't have a contract with him,
I don't have a contract with him.
then how it will be guided?
My lord, therefore, this, my lord, section 70 comes, and therefore the honorable single judge has taken note of the section 70 and said that you pay him. Otherwise, there is not a, my lord, clause in the, my lord, contract that the subcontractor will be paid directly. There's no such
No,
clause.
as far as the LD and imposition of LD and calculation, how it will be calculated, I mean, this code, I don't think this code can decide on that.
No, my lord, I'm on not that, my lord. I am on the legal principle. When the agreement is entered between only the BRO and the, my lord, valecha, whether the terms and condition of that be imposed on me. But I can cite certain decision of the Supreme Court that it cannot be, my lord. Then secondly, to fulfill the condition, my lord, of the section 70.
Your mechanism is not subcontracting. Your mechanism is, though you have been, I mean, brought in, but you are working as if you are a contractor. You are executing the whole work. Everything you have been doing. You have been given 49% of the
My lord,
responsibility.
my work is not that, my lord, independent of the principal contractor. Principal contractor, as I said, my lord, the engineering, this is EPC, my lord.
Engineering, design and all this.
Everything will be done by him. The milestones are fixed by him. The quality control, everything will be done by him. The authority will inspect, and then bill will be paid, and I'll be getting my amount. Now I am to execute only 49. He is to execute 51. He has not done a single work. And I have completed that, the 49%. And I have been victimized, saying that since contract has been not done, total contract has not been done, so the liquidated damage entirely, whatever the users will not impose on the principal contractor, but on you. But why, my lord? Question would be, my lord, they have to answer why, my lord. Why not valecha? What clause, my lord, exempt valecha from payment of these damages and imposes, my lord, which clause, my lord, exempts the, my lord, valecha from, my lord, the liability of payment of damages and imposes that, my lord, the liability on the subcontractor. There's not a single, my lord, even taken into consideration of the agreement. There's no such clause, my lord. Lordship will ask them why they are not, my lord, taking any action against, my lord, valecha, and till today they have not even blacklisted, they have not proceeded against. That is only two, my lord, the legal ground on which, my lord, my whole, my lord, the case is, my lord, I'm basing, my lord. So far as the second, my lord, section 70, the honorable single judge has accepted. Therefore, said let the pending bills, whatever else you pay directly to the petitioner. They have paid, but then taking note of clause 2, they have deducted this damages, etc. Now, thing is that whether those damages can be, my lord, imposed, which is a, my lord, terms and condition.
You have the main contract with valecha and the BRO?
Yes, my lord, it is there.
Then I can.
Did you? Affidavit in opposition to. Affidavit in opposition. Yeah. Maximum road. Second, directly directly payment treated as a contract, not your subcontract. Because he is not going to. Super. Still secrets was a pretty cool thing, but only because there's anything like this.
Yes.
My lord, in the termination order also, it will also reflect that they have said I have executed to the extent of 26.1.
No, after verification, direction for verification,
Got you.
how much work was found to have been done by you?
My lord, they, that page, according to them, I am to receive 11 crores 83 lakhs 38,098. Page 524.
Okay.
This is not the signed contract. Or it's a model contract.
Which one?
This one?
This is perhaps signed contract because they have been referring to. I've not checked up that portion, but
No, there is no date on the agreement, nothing.
you have the copy. They'll have the copy, my lord. They'll have the copy, my lord.
Yeah, this is, there is, yes, yes.
Amar bill kon give me. Then Amar bill.
Yes, it was signed on 9th of September 2020.
So according to them, my lord, place 5 to 4, I am to receive 11 crores 83 lakhs. Then after imposing all these damages, they have paid me 3 crores. Total. And this document is not signed by anybody, my lord. This document is not signed by anybody, my lord. Who has prepared it, my lord? Because after that, we have submitted the bill. After the joint verification, we have submitted the bill at page 482. That amounts to 18,77,000. And before this court, they have undertaken that they will process that bill within 2 weeks.
No, now you are agreed only with the second direction.
Second direction. Yes, my lord. No, I'm just, my lord, elaborating the argument, my lord, because the issues have come, my lord. How much deduction, this, that, and all. Otherwise, my only 2 questions that having fulfilled the section 70, Honorable Single Judge has directed in the third direction to pay the entire bill amount, whatever I am to receive to me. And so far as damages, etc., there has been relegated me to go to the civil court. Now, if I satisfy section 70 and the direction has been issued for payment, which is not a condition in the contract, my lord, and those damages part clause 10.3, etc., these are clauses in the contract where I am not a party. Whether that can be imposed, that clause can be imposed only for this purpose.
No, you,
And is there any clause in that, my lord, whereby the principal contractor in this situation is exempted from the liability, rather the subcontractor who executes, he is liable to pay? Even if it is said that this contract agreement, my lord, subsists or applicable, whether there is any clause as such, my lord? That is the only 2 questions, my lord. If it is not found favorable from this court, obviously, my lord, I have to go to the civil court. There is no other alternative. But these are the 2 legal questions, my lord. And on the point of section 70, my lord, I say, my lord, this is based on the principles of, my lord, unjust enrichment. A person cannot have the services and also he will not pay.
no, on the basis of principle contained in section 70, you were granted relief number 1 and relief number 3 by the
Yes, yes.
civil court,
That's
by the single bench. Now, as the calculation of damages, liquidated damages, and the fact as to who had actually deposited the bank guarantee are disputed facts. Then-
for a moment, bank guarantee may be, my lord, for a moment, bank guarantee may be excluded because it is in the name of, though, my lord, the document says it is from my account, from my amount, the bank guarantee was made, but it was made in the name of the valecha. So therefore, it will be a disputed, maybe, though there is no denial from this part, the valecha was made a party in the writ petition, they did not deny anything. So, my lord, Nasim Banu case, my lord, if it comes, my lord, what is not denied deemed to be, my lord, accepted. So, my lord, authority is saying that whosoever is depositing, we are not bothered. It was in the name of the valecha. But when I said that moment I received the 49% approval, I went to you, I asked you that you refund me the amount. I would not have gone for execution of the work. They said, no, you complete the work, we'll refund you. This has not been denied. This has not been denied by them. Now, Another question, my lord, while the relief number 3 has been granted based on section 70, can again be, my lord, condition of, my lord, agreement be, my lord, imposed, because section 70 is an independent of the contract. Had there been any agreement with anybody, section 70 does not come, because it will be governed by the agreement. This relief itself, granted in my lord, clause 3 could not have been given, my lord. And this has been, my lord, complied with. This direction number 3 has been complied with, but only, my lord, because of the clause number 2, though it does not say that you deduct, it is so far as, my lord, liquidated damage. The language is very clear. Your lordship will find.
The maximum is up to 10%.
That is, my lord, will be second limb of argument if, my lord, this honorable court holds that these conditions in the agreement are also applicable to you. Then only, my lord, the formalities, there are lot many formalities are there. They have to give me a notice. I have to be given an opportunity. I have to respond. Now only taking, my lord, recourse to this 2, they have, my lord, submitted this, my lord, 2 papers. And I have been repeatedly saying undated, unsigned documents. Who has prepared? How it has been prepared? Where is the calculation? Nothing is there, my lord. And so far as as per the joint valuation, I have submitted my bill, that is at page 482, and this court has passed an order that you process the bill. They have undertaken that we will be processing that bill within 2 weeks. That has not been done. But in the meantime, pleading complete, so hearing had taken place. That order, your lordship will find, my lord. It's an order dated 22/7/2024. No, I am just on the conduct and the interpretation of this particular clause by them. On that, my lord, I just wanted to highlight, my lord. Second paragraph onwards, my lord. In terms of the direction passed by this court, it is brought on record that a joint verification was carried out with regard to the works as stated to have been executed by the petitioner herein as a subcontractor, and a report there has been placed on record. So and so, appearing for the petitioner has submitted that quantity of work as executed in the matter being unbilled. The petitioner has submitted his bill for the purpose before the authorities, and the same is pending consideration. Mr. So-and-so submits that authorities be granted at least 2 weeks' time to process the bill of the petitioner in light of the joint verification report and pass appropriate order there. Now, the bill submitted by me is at page 482. And it is amounting to 18 crore 77 lakhs and odd. Now, they have prepared these 2 documents, page 524 and 525. According to them, I am to receive 11 crores and odd, and after deduction, I am to receive only 3 crores and odd amount. Even my lord lordship is, my lord, in the 226, my lord lordship will ample power to ask them why, my lord, the Bhalesa has been, my lord, exempted from these liabilities. At least, what is that clause of the, my lord, agreement which exempt, my lord, Bhalesa from, my lord, realization? Whether those things have been brought on record, my lord. They are local contractors, my lord. Why, my lord, this can be, my lord, imposed? Because it's a Bhalesa is a principal contractor who is, my lord, can, my lord, execute a work of 8 crores and odd. Not only this, my lord, the subsequent matter also, my lord, they are also the Velacha is the, my lord, contractor. It is analogous with this, my lord. They are also 80 crores. So it's a big contractor, my lord, the Velacha. There also another person has been subcontracted, and similarly, he is also been denied the amount. Just because these are the local contractors here and there, my lord, and with all money, I have given in the second, I have given, my lord, the notices from different banks which have come, my lord. Besides that, my lord, there is no, my lord, clause in this agreement whereby exempting in this situation exempts, my lord, the Velacha from payment of any of the, my lord, these liabilities and rather impose on the, my lord, the subcontractor. And if it is accepted, my lord, this contract agreement is, then also, my lord, whether this liquidated damage
Have been engaged in terms of 4.2 of the contract agreement.
contract agreement.
So 4.2 basically says that subcontracting can be done till 49% of the.
49%.
And all liabilities will be with the contractor.
That is 4.4.
The sad part is that like you don't have a contract, you don't have a separate contract with the contractor.
Right.
That is your problem.
Right.
You should have had a contract with the contractor.
Right. They should have insisted for an agreement.
That you don't have. You don't
Right.
have. Now let's see the payment terms there, how the payments are to be done. Let's see payment terms.
To the agreement, to the agreement that I got.
Who made the payment? BRO.
BRO.
As per the contract, whom the payment should have been made.
It goes to the escrow account.
From there, it will go to.
There's a division, there has to be division at certain amount the bank should issue to me and certain amount should go to the Velacha. But he has manipulated the entire things, nothing comes to me, so I had to complain to the authority, and authority has the power under the contract. That clause, your lordship will kindly see, my lord. 4.3, quoted at page.
The escrow opening clause is there in the contract, or it was not there. It was not there.
Well, this page 53, clause number 4.
53 of the.
Of the this appeal memo. I have quoted the clause 4.2.
That I have seen. Yes, sir.
No, my lord, so far as 4 is concerned, my lord. Clause 4.2.4, page 53. It is expressly agreed that the contractors at all times be responsible and liable for all its obligation under this agreement, notwithstanding anything contained in the agreement with subcontractor or any other agreement that may be entered into by the contractor, and no default under any such agreement shall excuse the contractor from its obligation or liability under this agreement. However, in case of non-compliance of the contractor towards his obligation for payment to the approved subcontractor, which is likely to affect the progress of work, the authority reserves the right to intervene and direct the contractor to release such outstanding payment to approved subcontractor out of the payment due for the completed works in interest of work. But I have complained to them, my lord, and pursuant to them, they have issued one letter, my lord, at page 157. Last paragraph, paragraph 4. It is intimated that issue regarding non-release of payment of subcontractor has been raised and communicated to you several times, but you have failed to settle the issue with subcontractor. In this context, this headquarter letter number so-and-so dated so-and-so and so-and-so dated so-and-so may also refer. In view of the above, it is directed to release balance payment of work executed by subcontractor at the earliest and submit your feedback to this headquarter so-and-so. But no payment was released, nothing was released, nor even the, my lord, they have taken any further action on this. My lord, notice of intention of termination was issued way back on 7/2/2023, but I have been allowed to work. They should have stopped, my lord. That since subcontract is going to be terminated, so you stop work. Till the date of termination, which was, my lord, done. 16/12/2023, I was allowed to work.
Yes. Okay.
I think we have understood your case.
Lord,
So
I'll
let's hear them.
Yes,
I mean,
I'll just submit, my lord, few of the decisions or, my lord,
let him say, because I mean, your only problem is that now what we could understand is that like, I mean, LD was paid on the full amount on you, rather than like it should have been paid. I mean, it should have been invoked against the contractor also.
principal contractor.
Principal contractor.
And
The principal
compens-
contractor has the full liability.
Full
The
liability.
whole thing. As per the contract, you are only the subcontractor.
Right.
So it shouldn't have been imposed on you, the whole liability of LD.
Right.
At least the LD, and you have other
And
grievances also.
compensation, etc.
But
compensation.
at far as
For
the
time
LD
being,
is concerned.
for time being, this LD may be, I mean, this bank guarantee may be kept aside, my lord, because this
There's a
scenario,
dispute,
what is
yeah,
appearing
yes.
that though I have paid the amount, but it is in the name of the violator.
Let us hear him.
My pleasure, Lord. Malad, our precise and simple case is, a contractual agreement was made between the Malad, the respondent number 6, Belesia, and the Malad, the employer Malad, BRO Malad. And Malad, when the work was awarded, Malad, it may be Malad, the amicable settlement made between the Malad, the present appellant and the Malad, the Belesia company Malad. Malad, our contractual agreement, everything is with the Belesia Malad. We therefore Malad, in the affidavit, Malad, we have clearly stated that we don't have
But what
any.
about 4.2?
4.2 is Malad, that is the Malad, the Malad, allowed to Malad execute the work to certain extent Malad.
What sustained
In-
49%?
In the name of Malad, yes Malad. In the name of Malad, even 49% is allowed, even that is Malad within the ambit of the Malad, the respondent number 6 Malad.
Hmm.
Everything has to be done through the Malad, the respondent number Malad 6 Malad. We are now having Malad, the contractual obligations with it.
Understood. Now let's cut it short. And why you have imposed the LD or LD of the whole contract for him?
Malad, it's because there is no separate Malad, the provision Malad.
Why?
It is only for the Malad entire works.
49% of work they will be done by.
No, Malad, that is within the Malad, the scope of the execution of the work. Malad, when Malad, the security has to be taken, Malad, it is in respect of whole works, Malad, not piecemeal, Malad. So therefore, Malad, in 49, Malad, with regards to the 49%, Malad,
So who is liable for the LD?
LD, Malad, admittedly, Malad, this principal contractor, Malad.
Then why you have not imposed LD on principal contractor other than him?
Malad, as per the Malad direction of this honorable
As
court,
per the contract agreement, who is supposed to pay LD when the contract is not performed as per the contract?
Malad, fairly, Malad, it is principal contractor.
Then why LD has been imposed on him rather than imposing on the principal contractor.
Malad, we are not separately imposing him. It is in the name of the
Why
Malad.
you have imposed him? Then as per the contract, you are saying that the contract is not with him only. Then the LD should have been gone to him because this is their internal understanding that that is
Yes,
your
ma'am.
submission.
Yes, Malad.
Then if that is your submission, then why principal contractor has not been asked to pay the LD? And why that subcontractor has been penalized for that?
Malad, sir,
Because all the liabilities with the principal contractor.
yes, Malad.
Then
Malad, everything is with the Malad, the principal
then why you
contractor.
have imposed LD on him and without giving him any notice, without giving him any calculation, you have simply deducted his money.
Malad, as I pointed out, Malad, the appellant is not in the picture, Malad.
Who is not in the picture?
Appellant is not in the picture. Therefore, Malad, he has been only allowed to execute the work in the name of the principal contractors. Therefore, Malad, Malad, that fixation has been done, Malad.
But while, I mean, you don't want to pay him, but while imposing the LD, you impose the LD on him. Deduct his money. How can you do that then?
Malad, precisely what happened during the pendency of the writ petitions, Malad, the joint verification was for joint verification direction was issued. Accordingly, we verified the site, Malad, jointly, Malad.
Correct.
Even after the Malad termination, Malad, admittedly, he is the Malad, the honest contractor. Even after termination, he Malad to keep on working, Malad, executing the work to a certain extent, Malad. Thereafter, verification was done, Malad. The amount was also calculated. That has already been duly Malad, calculated after Malad, wherein he has also put his signature, Malad. After joint verification,
That's correct.
certain
No, joint verification has been done as per the direction of the court, right?
Malad is still there, Malad. My respectful submission is, Malad, as per the direction of the honorable single bench, Malad, it is very limited, Malad. Malad, that scope is not, Malad, foreclosed, Malad. That scope is still remain intact as because this is the only disputed facts, Malad, to only direction number 2 only, Malad. It is not in respect of other things, Malad. It is in respect of the, Malad, performance bank guarantee, Malad. Malad,
No, and only a simple query that we are asking is that, see, the whole contract is of around 67 crores, right?
true, Malad.
So 67 crores of contract was given to Velicha.
Correct, Malad.
Then Velicha wanted to subcontract certain portion of the work.
Malad.
And as per your contract, 49% can be
49%.
subcontracted.
Yes, Malad.
And as per your approval, Velicha has engaged the subcontractor.
Yes, Malad.
Now, there was some dispute about non-performance and delay, all these things have cropped in.
Yes, Malad.
So contract is terminated.
Terminal.
Now, since he has completed certain portion of the work, he has come to the authority saying that I have performed certain portion of the work, so you pay me the money, I have not got the money, correct? So you did a joint verification. You have done joint verification, you paid him the money, whatever work he has done.
Yes, Malad.
Now, while doing so, you have deducted certain LD. Now, LD you have deducted on the whole amount, that's 67 crores on him, taking the maximum. And you have not given any calculation also. See, LD is usually what? Per week, per month. If it is delay, per week, per month. And as far the performance is concerned, then there has to be some performance, I mean, below standard performance that has to be seen, how it is to be calculated. Then only LD will be imposed, right? Now you have imposed the LD without doing all those activities, and you have imposed LD on him of 67 crores. Rather, he has performed only 49% of the contract value.
Malad, as I pointed out, Malad, it is not on the piecemeal calculation, Malad.
What
It is,
piecemeal? You have given
it is for the entire work, Malad.
You have given 14% to him.
49% within the umbrella of the Malad, the principal
That's why
contractor.
then we impose the LD on the principal contractor. Why you are imposing on him?
And Malad, whatever we have paid is paid in the extra account.
You give a simple answer. See, the whole contract is of 67 crores.
True, Malad.
LD is maximum 10%.
Yes, Malad.
Correct. So what you have done, you have imposed LD on him. 10% of 67 crores
Directly,
on him. But you are, on the other hand, you are saying that like the principal contractor is a person who is liable because I'm having a contract with him only. You are working under his umbrella,
Yes, Malad.
but you have deducted from him. How can you do that?
Malad, to that extent, Malad, if Lordship allowed, may I take instructions to that extent, Malad?
It should have been clear with him by this point of time. I mean, it was before the writ court also.
Malad,
67 crores.
Malad, actually,
See,
the-
67 crores, 10% is the maximum LD you can impose on the contractor.
Malad,
Now it has been subcontracted to somebody. Now you have imposed the whole LD on him. There is nothing remained for the, nothing remained to be paid by the contractor.
Malad,
If he does some
on that, Malad,
delay or substandard performance.
on that aspect, Malad, my respectful submission is, it is for the entire work, Malad. We don't know, Malad, who has deposited. Malad, we only know that principal contractor is the authorized persons to,
So
Malad.
you put LD on him. Why you are putting LD on him then for the whole contract? Whereas he hasn't done the whole contract. With your approval, he has done only 49% of the work.
So therefore, Malad,
Is it correct?
my
Is it
respectful,
correct proposition?
my respectful submission is, Malad.
See, contract was basically bifurcated,
Yes, Malad.
49% and 51%. 51% is being done by the EPC contract.
But, Malad, still payment has to be made to the principal account.
Correct.
It is,
So
in
LD has to
respect
be
of the execution of the work,
so
Malad.
LD has to be imposed on the principal contractor only. And you have not bifurcated that. You have put on 10%, the maximum LD on him only.
Malad, may kindly appreciate one thing, that entire work has to be executed in the same spirit, Malad.
I mean, we are understanding that,
Malad-
but
Malad,
no, we are
The-
understanding
in
that.
respect of execution of the work, Malad, that may be piecemeal, Malad. That will be within them, Malad.
So he will be doing 10%.
But, Malad, whatever the payment is to be made,
Mr. Kato, do you want to say one contractor is performing 10% of the work? Then you'll put the whole amount, the LD of whole amount on him. If he delays,
Malad, it is 10% is in respect of the Malad, the 10% is out of Malad 6 crores, Malad, he has deposited, Malad, in the name of the Valencia, Malad, respondent number 6, Malad. It is in respect of the entire work, not for the Malad, the work for 49% which he has been allowed, Malad. Even the payment has to be made, Malad. Everything has to be released within the extra account, jointly opened, Malad, by them, Malad. That is the payment, Malad. We have not, Malad, paid singly, Malad. Even we have not deducted singly, Malad.
whoever is paid, your 100% work is not completed as yet.
No, Malad.
Only portion of the work is completed.
Yes, Malad.
So LD has to be proportionately. LD cannot be on the whole amount.
Malad, that is the,
And,
Malad,
if you
that
do-
is the,
no, no,
Malad, Malad, that is,
If you do it on the whole amount, then the principal contractor is liable.
Malad, that is the Malad, that is the contractual agreement between the Malad, the Valencia, Malad. There is no Malad, in respect of certain works to be executed by him, wherein Malad, that piecemeal Malad, the arrangement is made, Malad. That is the Malad, Malad, the submission which we have made before the honorable single bench also, Malad. Now, Malad, come to the Malad, the present issue. Even, Malad, to my respectful understanding, it is not Malad on other issues. The issues in respect of the point number 2, wherein Malad, it is the disputed pact by them, Malad, who has Malad created performance bank guarantee, Malad. For performance bank guarantee, Malad, it is not known, Malad, who has Malad created, who has deposited, from where source of income this amount has been Malad deposited with the bank, Malad, for the execution of this particular work, Malad. Therefore, Malad, the honorable single bench has given the directions for Malad relegating the matters to be Malad decided in the Malad civil court. So therefore, Malad, issue is very simple. Rest part is Malad, Malad, for non-execution, for non-compliance of the Malad, the order passed by the honorable single bench, Malad. Even contempt petition is also pending, Malad, and same has also been listed today, Malad, in its honorable single bench, Malad. Now, Malad, in respect of this particular bank guarantee, Malad, it is not known, Malad. Our contention is, Malad, simple, Malad, the bank guarantee has been deposited in the name of Malad.
That is performance bank guarantee. That is fine. That is
Yes, Malad.
with
So therefore, Malad, there is
we are with the liquidated damages.
my respectful submission is, Malad, that is the Malad, my submission, Malad. There is no moral infirmity where Malad, this honorable court can interfere with the Malad judgment in order passed by the honorable single bench. It is very much clear, Malad. The rest amount payment, other things, that has already been settled.
Okay.
This is my respectful submission, Malad.
Okay.
In respect of this particular appeal, Malad, wherein Malad, this is in respect of this particular direction number 2, wherein Malad, It is the only, malad, the matter of facts, malad, where evidence has to be taken from where source of the income has come, who has malad created.
He has another ground also. That ground was there, how they can impose that grievances against you, how you can deduct 10% of the LD from him only.
Malad, my respectful submission is, malad, that is not part of the.
That too without issuing any notice to him as to how it was calculated.
Yes, malad, to that extent, malad, I have already malad submitted malad that malad everything, if it is to be communicated with the malad, the communication has to be with made with the malad respondent number 6 only, malad.
So you do to him, then why you have deducted 10% from him? From the whole contract?
Malad, my respectful submission is not from him alone, malad. It is in the name of the malad, the Valencia, malad, respondent.
His bill you have deducted, or you are saying Valencia?
Malad, deduction.
From his bill you have deducted.
Malad,
The
deduction.
bill was paid to him. Was it paid
Malad,
to
deduction.
Valencia?
Malad, deduction is in respect of malad, the work executed by him and the payment which has already been released in that aspect, malad.
No, had it been like that, it would have been very nice. But what your authority has done is that deducted 10% of the whole contract.
Contract amount.
The whole contract amount, 10% has been deducted. So how can you do that?
Malad, to that extent, malad, there must be certain provision, malad. May I take instruction to that extent, malad, how this amount has been deducted?
No, that's.
There must be certain provision, malad, by which malad, there are malad, technical calculation, malad, even we don't know malad, how it has to be calculated. Yes, malad. There are several malad, the counts, on several counts, malad, deduction has to be made, malad. Even we don't know malad, how, malad, in my affidavit earlier, in the single bench, before the honorable single bench, malad, we malad, filed our additional, affidavit, malad, wherein malad, such deduction is made, malad. There are numbers of malad deduction that has to be made, malad. Unnecessary deduction cannot be made, malad. The deduction, malad, there must be certain provision, malad.
No, this is LD for delay, right? This is liquidated damage only for delay.
Malad, the liquidated damage, malad, this
So
has
liquidated
directly caused and directly accrued to the malad, the department. Malad, for this non-execution of the work on timely, malad, malad, department has malad, even engaged another malad, the contractor for completion of the work, malad, where malad, huge amounts has malad, incurred. Malad.
No, you have a right to impose LD. Nobody is denying that. But only question that we are thinking that why the whole contract value, 10% of the contract value.
Malad, this is commercial transaction, malad, where the every damages is caused, malad. The liquidated damages can be malad, imposed upon, malad. That is not simply sitar bill, which can be directly paid, malad. That damages is always accrued with the malad, the whole.
Mr. Kato, liquidated damages can be invoked only as per the contract, not by nothing else. So if your
True.
contract that LD is there, then LD there, if there is a process how LD is to be calculated, and as per that has to be imposed on.
Well.
Now, if you are imposing LD, that's fine. There is no problem as per the contract if you are doing it. But LD, as per the contract, it seems it has to be imposed on the main contractor.
Well.
You have imposed on him the whole contract value, 10% maximum LD on him. Whereas he has performed only 49% of the work. That is with your approval. You are also aware of this.
Well.
That is the question.
Yes, Mr. Saikia. Citations.
So far as malad, the contempt we have filed, your lordship will file in the direction number 3, all pending bills, if not paid in the meantime, shall be released favor of the petitioner in terms of joint verification report. It does not say by deducting the damages, etc., as per this and that. They unilaterally they have deducted those amounts. So therefore, the contempt of this clause, violation of clause number 3, that is the contempt. And even if your lordship will find in the termination notice, detailed recitation has been given that the principal contractor has not done a single work. The entire work has been done by the petitioner. To the extent of April 2023, it is to 26.1%, 26.21%, that is 17 lakhs and odd. Then, my lord, after joint verification, according to their calculation, it is 11 crores and odd. And then, my lord, amount during the continuation of the work, some IPC amount they withheld, that amount comes to about, my lord, 1 crore 76 lakhs. Total comes to, my lord, 31 crore 37 lakhs 44,256.
Is it to be performed phase wise?
My lord?
Is it to be performed phase wise, work execution?
No, there's no such reason. He will my lord, go ahead with 51.
It can be independently performed.
Yes.
It is not dependent on your work.
No, in fact, he has given an application before that. I have already moved my tools and machinery for performance of my 51%. My lord. That letter is also there on
Okay,
record.
then we understood your case. I mean,
Lordship.
now if you have some citations or
Lordship.
whatever, you can.
So if your lordship, there's another statement that out of the scope of work that is granted to me, 1.5 kilometers, 1.25 kilometer, they could not give because of a my lord, local dispute due to, my lord, this hydroelectrical project. That is admitted. They have not denied. So this 1.25 kilometer, that is valued 20 crores.
So you could not perform that.
So 20 crores has to be deducted from the, my lord, 33 my lord, crores and odd, my lord. So that portion, so therefore, my lord, I have done more than 49% of the work, my lord. 31 crores, 37, my lord. These are different pages, my lord. I can take your lordship the figures, admitted figures. This 26.21 is admitted, my lord, at page 177, my lord. Then, my lord, at page 482, my lord, this IPC, my lord, statutory deduction, that is 176, my lord. Page 177, lordship, may kindly come, my lord. Page 177. There's no delay on my part, my lord. 177, my lord. Serial number 2, milestone so and so. Only 26.21% has been achieved till 27. This is by me. Then lordship may come to the, my lord.
No, these things are fine, but
Page 180. And only just.
problem is that this court won't be having that much of jurisdiction to do lot many things.
Lord, only, my lord, page 181, my lord. Paragraph 12, last paragraph, whereas as per clause 4.2.1 of EPC agreement, the contractor, whether joint venture or sole, shall not subcontract any works in
No,
more
that we have read.
ordinary. The, my lord, here it is clearly in the next line, it is said that the principal contractor has not done a single work. It is entirely done by the petitioner, my lord.
51 to 7
What decisions you are relying on?
Lordship. My lord, this is, my lord, whether the third party can be imposed with the condition, my lord, where he is not a party to the agreement, my lord. My lord, AR 1970, Supreme Court 504, my lord. Paragraph, I'm relying on paragraph 9,
AR 19?
AR 1970, Supreme Court 504.
You are giving 2 copies of,
My lord, some, can
70 is not there probably.
perhaps 70 both copy gone to my lord justice.
Just a minute.
They all these copies are 2 copies. You are giving.
Two copies, my lord.
But we'll do one each copy, my lord. And then-
চারটা কপি আছে এটা কমপ্লিট করে নিলাম
Yes, 1970, but it says.
Paragraph 9, my lord. The Kottayam Bank was being a party to the deed was not bound by contraventions in the deed, nor could it enforce the covenants. My lord, here Kottayam Bank was not, my lord, that word is missing, that I'll clarify from the subsequent paragraph, my lord. It is settled law that a person not a party to a contract cannot, subject to certain well-recognized exception, enforce the terms of the contract. The recognized exceptions are that beneficiaries under the terms of contract or where the contract is a party of the family arrangement may enforce the covenants. Clause D of Section 2 of the Contract Act widens the definition of consideration so as to enable a party to a contract to enforce the same in India in certain cases in which the English law would regard that party as the recipients of a purely voluntary promise and would refuse to him a right of action on ground of nodam pactum. Not only, however, is there nothing in Section 2 to encourage the idea that contract can be enforced by a person who is not a party to the contract, but this notion is rigidly excluded by the definition of promisor and promisee. Now, this is, my lord, Lordship will read, my lord, paragraph 10 as well, my lord. Even if to be granted that there was intention to create a charge, the Kottayam Bank not being a party to the deed enforce the charge only if it was a beneficiary under the terms of contract, and it is not claimed that the bank was a beneficiary under deed of exhibit D1. The suit so. Then second, my lord, AR 2004, Guwahati 19. I'm referring to paragraph 8, my lord. I'm not referring to the whole thing, my lord. Paragraph 8.
Yes,
Paragraph 8, my lord. May I read, my lord?
yes.
It is next contended that the learned appellate court cannot direct the petitioner to return the earnest money where there is no stipulation to finalize the tender within 3 months. The point to be determined is not whether there is the stipulation to finalize the tender within 3 months. Rather, the crucial point is whether the petitioner has the right to retain or to forfeit the earnest money. Both the courts below have given a categorical finding that there being no agreement, there was no breach of contract committed by the respondent, and also that since there was no breach of contract, the petitioner cannot retain or forfeit the earnest money deposited by the respondent by way of penalty. Then one more decision on this point. Is the AR 2000, Himachal Pradesh 108. Paragraph 17. The doctrine of privity of contract implies a mutually at will and is interaction of parties and their successor. It creates a legal bond or tie or vinculum juris personal to the parties. The rule does is that no one except the parties to the contract can be bound by or entitled under a contract. The doctrine which defers third party to enforce a contract forbids the parties to the contract from enforcing any obligation thereunder against stranger. A person cannot be subject to obligation of a contract to which he is not a party, and logical consequences is that a stranger cannot acquire right under a contract. This is general rule, no doubt is subject to certain exception. Now, my lord, on the point of, my lord, this section 70 of the, my lord,
Contract Act, which although has accepted but not discussed, so therefore, my lord, the 3 citations, my lord.
No, on the basis of 70, you were granted relief number 1 and 3.
1 and 3.
So
Lordship.
that may not be required again.
Lordship. That is true. That is true. In this judgment clearly said, it is not because of any agreement or something, but it is the act which has been legally done and not gratuitously done, and therefore the other person is getting the benefit and he should be paid. That is the concept of section 70. Well, I conclude.
Third, Mr. P. Jeswakya, Learned Senior Counsel, assisted by Ms. M. Nirola, Learned Counsel for the appellant. Also heard Mr. M. Kato, Learned Deputy Solicitor General of India, representing all the respondent.
My lord, I am for respondent number 1, 2, 3, and 4, my lord.
Respondent number 1, 2, 3, and 4. And Ms. Pangu, appearing for
Respondent number 5, Your Lordship.
respondent number 5. Though this matter was listed for admission hearing today, however, it has been heard, the appeal has been heard for final disposal. Hearing concluded, judgment reserved.
Right.
This contract copy we are keeping. This contract copy you keep it the file. Keep it the file.
Item number 8.
Please, your lordships. Lordship, I'm appearing on behalf of the appellant in this instant matter. This is an application seeking condonation of delay in filing this instant
Your issue.
criminal appeal against the judgment of the Learned Sessions Judge UPR.
How much is the delay?
Lordship, may Lordship, sorry for interruption, Lordship. Lordship, the same matter, Lordship, is pending before the this court, Lordship, as a jail appeal, Lordship. This is
Why it has come to DB?
yes, Lordship. Yes.
Your lordship, the delay is by approximately
Jail appeal by the same.
Yes,
appellant.
Lordship,
Yes.
same appellant, Lordship.
Oh.
Lordship,
appeal
this is
is
the
ordered.
order, Lordship, that is, in the last order, Lordship, the paper book is directed to paper to be made, yes, Lordship.
No, you have preferred the jail appeal earlier. Why the second appeal is required?
Your lordship, respectfully, we are actually considering a bail for the appellant, and that's why we have filed this IA.
No, you can pray for relief in the pending jail appeal.
Order jail appeal is pending.
Is this the same appeal?
Yes, yes,
It's still pending?
yes.
Okay, so
You were not aware that jail appeal has been already filed.
actually,
by the
your
same
lordship,
appellant.
your lordship, I have drafted this IA. My learned senior counsel's name did not appear on the cause list, so I was asked to brief the matter.
Who is a senior counsel?
JM Chaudhary, Mr. J.M.A. Chaudhary. Actually, he is presenting the case, LP Bora.
No,
Thing is there, yes.
otherwise, this
Yes, Lordship.
interlocutory application is infructuous. It is liable to
Yes,
be
Lordship,
dismissed.
this present appeal is not maintainable, Lordship. It's already, Lordship, is pending before Lordship.
Question of condoning the delay does not arise because the jail appeal has been admitted.
Lordship.
Already.
And already directed to paper book to be prepared, Lordship. LCR, TCR also been called for, Lordship.
May I request this honorable court to give us a date
For what?
For what?
for the jail appeal, because I was
Already,
absolutely not aware of that.
withdraw because it's already been pending.
Thank you.
It's infructuous.
He can, what he can do is to withdraw Lordship because it's already pending, Lordship.
You withdraw already, jail appeal is already
Okay.
there.
You are withdrawing or we are dismissing?
Should we withdraw it? Okay, we would like to withdraw your lordships.
Okay. Heard, Mr. What is the name?
KG Chaudhary, your lordship.
KG Chaudhary, learned counsel for the applicant. Also heard Ms. L. Hage, learned public prosecutor. This interlocutory application, though this interlocutory application under Section 5 of the Limitation Act has been filed by the applicant Vijay Bora, praying for condoning the delay of 2,777 days in preferring the connected appeal, whereby the appellant has impugned the judgment and order dated 24/2018 passed by the Court of Learned Sessions Judge UPR in Sessions Case number 5/2014, whereby the present applicant has been convicted and sentenced under Section 376D of the Indian Penal Code. However, Ms. L. Hage, learned public prosecutor, has brought it to the notice of the court that an appeal in the form of jail appeal preferred by the present appellant is already pending before this court. The said appeal has been registered as Criminal Appeal Jail number 7/2023. She also submits that in the said appeal has aforesaid jail appeal has already been admitted and registry has been directed to prepare the paperwork. In support of her submission, she has produced a copy of order dated 23/12/2025 passed in the aforesaid Criminal Appeal Jail number 7/2023. So, in view of submissions made by learned public prosecutor, the learned counsel for the applicant prays for withdraw. Learned counsel for the applicant submits that he was not aware about the pendency of the aforesaid Criminal Appeal Jail and prays for allowing the applicant to withdraw the instant application. The prayer is allowed. This interlocutory application is dismissed on withdrawn.
Much
Obliged, your lordships.
Item number 9 and 10.
May it please, my lord. My lord, item number 9 to 12 is a connected case arising from the same judgment. And I filed IA for suspension of operation of judgment and conviction and sentence, Your Honor, my lord. This is life imprisonment under section 302 IPC.
You'll file objection.
Yes, we received this IA only on 27 of this February, month of February, Lordship. So we need some time to file Lordship, objection, Lordship.
What is your name?
J. Adoji. I am legal aid counsel for the appellants.
Ms. J. Doji. How these cases are connected?
These are, my lord, arising from same judgment. There are three convicts in this case, my lord, and I have already filed suspension for another accused in earlier occasion.
Okay. In item number 9 and item number 11, both are application for suspension of sentence.
Yes, my lord.
In item number 9 and item number 11, heard Ms. J. Doji, learned legal aid counsel for the applicant. Also heard Mr.
D. Loy, Lordship.
D. Loy, learned public prosecutor,
Yes, Lordship.
appearing for the state. This application under section 430 of BNSS 2023 has been filed by the applicant / appellant, praying for suspension of the execution of the sentence imposed upon the applicant by the judgment dated 22/3/2024, passed in sessions case number 13/2023. By which court?
Bomdila.
By the
District
court,
Session
by the
Court,
Court
Bomdila.
of Learned Sessions Judge Bomdila West Coming. Stop. You have received the copy of Intel.
Yes, Lordship. On 27.
Learned public prosecutor submits that he has received, that state would be filing a written objection against the prayer made by the applicant, and some time is prayed for filing written objection. The prayer is allowed. How much time?
Lordship, 2 weeks.
Let this matter be listed after 2 weeks.
Yes, complex.
May it please your lordship, my lord. Judgment, my lord. There is in one matter, item number 11, my lord. 11.
Yes.
When the matter came up on the last time, we mentioned before because it was in the list and we said there is an urgency in this matter. And there was also, if your lordship looks into the file, there is some urgency in the matter. We have filed an IA. IA, yesterday?
Yes.
Yesterday we filed. If it is not inconvenient, can it be brought, my lord, the IA?
Okay, bring the, okay.
There is some urgency if it is possible today itself. I don't know.
Let us,
Because your lordship has got some admission matter. Thereafter orders. So if once the admission matter is over, then if your lordship can give a priority in this case, my lord.
let us see.
Because it's not take much time in this matter, my lord. Because it's a reference matter where they have come up before this court. The
The
petitioner
matter would not take much time. It is the very favorite submission of all lawyers.
Oh, no. As a lawyer, my lord, this is a submission which is normally made in the court itself, my lord.
Because today we spent entire half hearing one matter where Mr. Sakya said that it will take 10 minutes only.
But when I start, please see the watch. You can also see it'll take about 10. When I say 15 minutes, it'll take 15 minutes only. That I can assure. And you can stop it after 15 minutes.
No.
That's the best.
It depends upon the understanding capacity.
No, your lordship will understand. It's not that. Lordship is experience.
Your assessment is on different.
No, your lordship has got experience. It's not that.
Okay, we'll see your matter.
Yes,
if
my
it
lord.
reaches.
There are two matters. One of my learned friend is 11 and 13, my lord.
Okay.
The IA can be called for, my lord.
Yes, please call the.
I'm deeply obliged, my lord.
Your Lordship, I would like to mention one urgent matter, my Lord. Actually, this matter was listed yesterday, but took down of listed today, my Lord. It is an urgent transfer matter, my Lord. If your Lordship could accommodate it today, my Lord, else,
Not today, day after tomorrow.
my Lord, they may release me, my Lord. Okay, my Lord. Okay, my Lord, then day after tomorrow in this, my Lord, please make it this item number 1, my Lord, because I am in serious urgency. They may push me away anytime.
On that day you mentioned, now you give the mention memo day after tomorrow.
Okay.
Yes.
May it please your Lordship, I'm on behalf of my senior, learned senior, Techi Itatara. Lordship, I seek permission to mention an unlisted matter, WPC number 593/2025 for order.
Day after tomorrow.
Yeah, yes, Lord.
Okay, day after tomorrow.
So, okay,
Allowed day after tomorrow.
day after, sir, on 6/3.
On 6/3.
6/3, yeah. May this
That
matter-
is day after tomorrow.
Yeah, yes. Sorry. Thank you.
Okay.
May it please my lord.
Yes.
The 6th.
Yes, Mr. Sharma.
May it please my lord. I'm appearing in item number 14 and item number 15 of today's list. My lord, these are two alleged contemners who have filed these applications for striking out their names. One is the chairman of the Airports Authority of India, other is the regional director Northeast. My lord, it is a simple matter. My lord, notices can be issued and a date may be fixed for hearing, my lord. Preferably on 18th of March or 20th of March as per your lordship's convenience.
Okay, we'll pass the orders when the matter is called.
My lord, my junior Mr. R. Dubey is also there. He's there physically
Okay.
present.
Le-
My lord, my name may be recorded and my lord, my prayer is that
okay.
necessary notices may be issued and
Okay,
the parties may be heard, my lord.
We'll reflect your name
My lord,
and pass the order when the matter is called.
my lord, my lord, my lord. I'm very much obliged, my lord. I'm very much obliged.
Yes. Yes, Ms. Nirul.
Let me speak your Lordship. Lordship, I beg to mention item number 4, Lordship. I have already taken consent from the respondent container, Lordship. This matter may be adjourned for 2 weeks, Lordship.
Heard. Ms. M. Nirola, Learned Counsel for the petitioner, who prays for an adjournment of for 2 weeks. She submits that she has informed Learned. You are there?
Yes, Lordship.
What's your name?
Why Gao, Lordship?
Also heard Ms. Y. Gao, Learned Counsel for the contemners, who does not oppose the prayer. Hence, the prayer is allowed. Let this matter be listed after 2 weeks.
May I, Lordship? Lordship, I beg to mention item number 1.
Yes.
We have taken consent from the petitioner, Lordship.
What is your prayer?
Sorry, Lordship, adjournment, Lordship. We will file affidavit, Lordship.
You have to make your prayer.
Lordship, adjournment for 3 weeks.
Heard Miss M.
Lordship, I'm appearing on behalf of K. Lolan, Lordship, for private respondent number 6.
Heard Miss Y. Gao.
Yes, Lord.
Appearing on behalf of Mr. K. Lolen,
Yes, Lordship.
Learned Counsel for respondent number 6, who prays for 3 weeks' times for filing affidavit in opposition in this case.
Yes, Lordship.
She submits that she has informed Learned Counsel for the petitioner who does not have any objection to the said prayer. Hence, the prayer is allowed. Let this matter be listed after 3 weeks.
Lordship, yes.
Interim to continue.
Interim order
There's
is
an
there.
interim, yes, Lordship.
The interim order shall continue till next day.
Obliged, Lordship.
May it please your Lordship. Lordship, I beg to mention for listing an I criminal on 19th of March, Lordship. It was listed yesterday, Lordship, but could not be reached, Lordship.
Okay.
19th of March. Obliged, your Lordship.
The kind indulgence to item 3, my lord. I have some difficulties after second half. It would be gracious if my lord can accommodate me for Monday.
You have informed the other side.
Yes, Lordship.
Okay. Heard Mr. T.T. Tara, learned counsel for the petitioner, who prays for an adjournment due to his personal difficulty. Ms. Y. Gao, learned counsel appearing for the respondents.
Lordship, I'm appearing on behalf of M. Kato, standing counsel for CBI.
Learned counsel appearing on behalf of Mr. M. Kato, learned central government state.
CBI, Lordship.
Learned standing counsel CBI does not raise any objection to the prayer made by Mr. Tara. Hence, the prayer is allowed. Let this matter be listed on
Monday.
Monday is
Okay.
Both sides are there.
Fifth. So which dates?
on 16.
Monday, next.
On 9th.
Yes, Monday 9th.
Ninth.
On 9th, 9th of March, 2026.
I'm grateful.
Lordship, the item number 2. I'm for the petitioner. Today only I have received the opposite in
Affidavit in opposition.
affidavit in opposite. So kindly give me some time to reply it.
Heard
Mine-
Mr.
R. Deuri
Heard Mr. R. Deori,
for the petitioner.
learned counsel for the petitioner. Also heard Mr. Y. Gao, learned counsel appearing on behalf of Mr. M. Kato,
Yes, Lordship.
learned Deputy Solicitor General of India. Mr. Deori, learned counsel for the petitioner, submits that he has received the
Today I have received the
affidavit in opposition filed by the respondents today only, and seeks some time to file a reply against the same. The prayer is allowed. Let this matter be listed after
Maybe after 3 weeks. Your
after 3 weeks.
Obliged, Lordship.
Deeply.
Item number 5.
Wait.
Yes.
Matter pertains to my lord cancellation of tender by the FCI. Pleadings are complete, my lord, if you're. Can this be, my lord, taken up for disposal, my lord?
No, we'll admit it for him.
Lord?
You are ready for
I'm ready, my lord. There is an urgency because, my lord, there is a stay of the tender, my lord.
but it is in admission stage. We have
Yes.
to admit it.
It has already been admitted, in fact, my lord.
Then
Not
why it is in
admitted, but your lordship can, if your lordship pleases, my lord, can take up in the admission stage also, but otherwise if it's some difficulty, my lord.
I have no problem if
Yes, your
lordship
lordship
is
pleases.
facing some difficulty today.
Next Tuesday, my lord.
Or Mr.
No.
D.
Wednesday.
Panging,
Man.
learned counsel for the petitioners. Also at Mr. What is the name?
B.K. Singh for the FCI respondent.
At Mr. B.K. Also at Mr. B.K. Singh, learned counsel for the respondent number
My lord, 225, my lord.
225. It is submitted at bar that pleadings are complete in this matter and the matter is ready for hearing. Considering the urgency shown by the learned counsel for both the sides, let this matter be listed for hearing. Choose a date.
On 11th, my lord, 11th of March, next Wednesday.
Is
my
it
lord.
okay?
For
My lord.
let it come up for admission hearing,
Admission
my
hearing.
lord.
No. It will come up for hearing.
Then it will not reach my lord.
I have no, sir.
If we fix
No,
everything
my
in
learned
admission,
friend is also in urgency to get it disposed, my lord. He will get the tender, my lord, if it is heard.
because we are fixing hearing matters in admission columns. Therefore, hearing item never reaches.
That is there.
Let this matter be listed again for final hearing
On 11th March.
on 11th.
Obliged.
Obliged, my lord.
Made to the. But item number 5, your lordship has admitted and fixed for hearing on 13th.
Yes.
But there was an interim order in that case. I've informed Mr. Singh also.
Okay, interim order shall continue till next.
Right.
Item number 5.
Item number 6.
Your Lordship. Your Lordship, in this case, pleadings are complete. Even we have exchanged the pleadings, and this matter was related to excess drawal of salary, Your Lordship. And the petitioner is a retired employee. His pension is just stuck because of this only.
We'll fix a short date.
Yes, Your Lordship. Can it be, Your Lordship, on 26th of this month?
Okay.
Yes.
Heard Mr. What is your name?
N. Sharma, Your Lordship.
Heard Mr. N. Sharma, learned counsel for the petitioner. Also heard Miss
P. Sangeeta, Your Lordship.
B. Sangeeta.
P. Sangeeta.
P.
Yes, sir.
P. Sangeeta, learned government advocate, appearing on behalf of the respondent. It is submitted at bar that pleadings in this case is complete and matter is ready for hearing. So accordingly, list this matter for hearing on
26th of this month, 26th
of March.
Yes, Your Lordship. It will be go for hearing, Your Lordship.
Yes.
Yes, Your Lordship. Deeply obliged.
Item number 7.
Made to the. My lord, I have just received a copy of the affidavit filed by the respondents. Can this matter be taken up next Tuesday, my lord? In the meantime, if required, my lord, file reply. Otherwise, my lord.
Heard Mr. D. Panging, learned counsel for the petitioner.
Petitioners.
Also petitioners. Sole petitioner?
No, petitioners, my lord. Two of them.
Petitioners. Also heard Miss
P. Sangeeta, Your Lordship.
P. Sangeeta, learned government advocate representing the respondent.
1 to 4, Your Lordship.
Number 1 to 4. It is submitted by learned counsel for the petitioner that he has received the copy of affidavit in opposition filed by the state respondent today only.
Yes.
And therefore prays for listing this matter on
Next Tuesday, my lord.
on 12th of March, so that if required, he may file reply to the affidavit in opposition filed by the respondent in the meanwhile. The prayer is not opposed to by the learned government council, hence same is allowed. Let this matter be listed on 12th of March.
Obliged.
Item number 8 and 9.
Lordship, we have already filed our affidavit for respondent number 2 and 3, Lordship. As per the last order, respondents were supposed to file affidavit.
In
I have already filed.
in the main case or
In the main case.
and in I
I also, we have raised objections, Your Lordship.
Lordship, the respondents were directed to file the reply within 10 days. They are giving specific directions to file the reply within 10 days. So far, only two respondents have filed the reply. That is the 2 and 3 and respondent number 9. So, Your Lordship, despite giving specific orders, they haven't filed the reply. So it can be assumed that they don't have anything to file, Your Lordship.
Yes.
So I
have yet to receive instruction, RW, respondent number 7. Otherwise, my lord, since the petitioner participate in the recruitment process, now they have not qualified in the written examination. So similar categories person, there are so many qualified person. Now he is out of race. So he have not qualified in the written examination. Now no more grievances lies.
That is not the case, Your Lordship. And in fact, that is a very ridiculous way of seeing this case. Because, Your Lordship, had I...
Who are you?
I'm R7, respondent number 7.
Respondent number 7.
RWD.
You file a reply, formal reply, if you have taken. Yes.
Here for 1, 5, 6, and 8. We are also yet to receive our instructions. Extra copies were served only on the last of it.
No, but a specific time frame was granted to you.
My lord, I am referring to respondent number 4. Sometime may be given to file the application.
Sometime was granted earlier.
Within 10 days, it is not possible, my lord.
Then you should have stated.
The petitioner's prayer was to state the result. The result of
Yes, Your Lordship, this is a very urgent matter, and it pertains to the illegal reservation for the persons with benchmark disability. We have not.
You take 1 week's time.
Yes.
Your Lordship, the urgency is that the result, the prelims has been already started, and now they are the APCS. They are about to begin the selection process from the 9th of March. Therefore, if they are paying time, Your Lordship, at least I have to take the appointment of the person with.
No interim relief.
Because, Your Lordship, I'm not praying for the whole recruitment process. I'm praying only for in respect of the PWD, Your Lordship.
Let them file. You take a. If you fail to file, we'll at least dispose of the.
Yes.
IA, Your Lordship, in IA, they have prayed for staying of the result, written.
The staying of the further process, not the result.
Result has already been declared and.
This has become infructuous.
Yes, Your Lordship.
No.
And more so, the prayer which they have made in the IA, that was already rejected in the main writ petitions. So this IA is not at all maintainable, Your Lordship.
No, Your Lordship.
They would have, instead of filing IA, they ought to have filed appeal against that
Where
order.
it was rejected.
Your Lordship, let's go to the first order. The order of the motion only just moved. That is order dated 21-1.
In IA, Your Lordship, they have annexed, Your Lordship.
21-1. And the operative person is the last paragraph, Your Lordship. Mary, Your Lordship, the last paragraph.
No, your prayer was rejected.
Lordship. Yes, Your Lordship.
The stage remains same.
No, Your Lordship. When this case was moved, at that time the result was not declared, and even the observation of the Your Lordship on that day was that it is too early to give stay. But now, Your Lordship, the situation has changed. Now they have already result declared. The change in circumstances, and any interim order is subject to vacation or modification whenever there is change in circumstances, Your Lordship. My stand today is that the circumstances have changed. It is not the way it was when this petition was moved. At that time, the observation taken was that it is too early to grant stay. But now it is no more early, Your Lordship. They have already declared the result, and second best result is.
There is no urgency.
Because
now let them file.
Lodge.
He have annexed the result sheet also. After the declaration result, how we can say that to stay the results?
No, the IA is not for the stay of the result, Your Lordship. The IA is only for the stay of the further process, not for the stay of the. No, I'm not. That is the main difference, Your Lordship. In the first interim prayer, it was for the stay of the result, but now it is for the stay of the further process of the examination, Your
Mr.
Lordship.
K. Taja, learned counsel for the applicant. Also, Miss, what is her name?
Enanju, for respondent number 2 and 3.
Learned standing counsel. APPSC representing respondent number 2 and 3. Also heard Mr.
G Tarak,
G. Tara,
Standing Council RWD for respondent number 7.
Standing Council. G. Tara, Learned Standing Council, RWD, respondent number 7.
ठीक है
T.
ठीक है
T. Gadi, Learned Standing Council for respondent number 4. And N. Ratan.
1, 5, 6, and 8.
You are additional AG.
Yes,
Learned additional AG appearing for respondent number 1, 5, 6, and 8, as well as Mr. L. Prem Parme appearing for respondent number 9. None of the respondent has filed.
No, Lordship, I have filed. I have filed. For 2 and 3, I have already filed.
And 9 also have filed.
Though in pursuant to the directions of this court by its order dated 18/2/2026, respondent number 2, 3, as well as 9 have filed written objection against the prayer of the applicant made in this interlocutory application.
No, Your Lordship, in a main writ petition.
Has filed affidavit in opposition.
Lordship.
However, Learned Counsel for respondent number 1, 5, 6, 8, 4, and 7 have prayed for some more time for filing their written objection in the interlocutory application as well as affidavit in opposition in the main case. It appears that by order dated 18/2/2026, 10 days time was granted to all the respondents, which has already been lapsed. However, it also appears that in the meanwhile, the results of the recruitment written examination, which were sought to be stayed in the connected interlocutory application, has already been declared. However, as alternative prayer for halting the further process of examination was also made in the interlocutory application, therefore the interlocutory application still survives. Considering the circumstances, the respondents are given how much time? 1 week. Further 1 week time to file their affidavit in opposition. Let this matter be listed.
Your Lordship, one prayer. It may kindly be observed, Your Lordship, that if they don't file their affidavit by next date, the matter shall proceed. Because it is very urgent, Your Lordship.
No observation. On that day, you press.
Always.
Then, Your Lordship, at least the declaration of the result may be stated, Your Lordship. The declaration of the result in respect of the PWDs, Your Lordship. Not all the process, Your Lordship. Only in respect of the PWDs. That result declaration may be stated, Your Lordship, kindly. Because in
Learned Counsel for the petitioner / submits that in view of the failure of the respondents to file affidavit in opposition, at least till the next date, the declaration of result of the
PWDs
of the recruitment process in respect of person with disabilities may be stayed. However, considering these facts and circumstances of this case, this court is not inclined to grant this prayer at this stage before filing of written before filing of affidavit in opposition by all the respondents.
At least, your lordship, it's still subject to the outcome of this petition, at least.
Again, I will have to pass a resolution.
Then,
You wait till next.
the matter may be fixed on 16, your lordship.
Let this matter be listed on 16th of March.
Item number 10.
Lordship, conducting counsel for the alleged contender is appearing in another court. Therefore, this matter may be passed over for time being.
Okay.
Obliged, Lordship.
Item number 11.
Lordship, this morning I found that my learned senior counsel, he has filed one IA into this matter. So I have received a copy. So I have to file a reply. There are certain allegations in this IA that has to be controverted, Lordship.
I'm not pressing today this side. I'm pressing maintainability of the case. I'll not press this. Today, I'm not pressing it.
Maintainability of the
Maintainability of the writ petition.
petition.
That's your lordship will kindly look into it. What is the last order that has been passed by this court? Please see the last order that has been passed by this court. That is on 25/2/2026. Please see. 25/2/2026.
Lordship, if the
Please, first, please see, my lord. Maintainability, he further submit that for release that we have filed it. But the issue of maintainability of the writ raised by learned senior shall be heard on the next date. So, my lord, the maintainability, I am raising the point of maintainability. Writ petition at all is not maintainable. His own case, he has filed a case before the reference court. Reference court under 64. He comes to the court and states the reference proceeding.
Land acquisition matter.
Land acquisition matter. I'll just tell my lord what is the matter about. My lord, we are project notification issued by the state in 2012, my lord. 2012. Award was passed and we are the project affected families. We belong to a village known as Akuba village. They belong to Ampo village. The notification which was issued by the state relates to the Akuba village. Now in 2012, now opportunity was given by the Deputy Commissioner under Section 9. That was over. 2015 award was passed. Now this is a Heidel project. Now
Award was passed on
award was
New
passed.
Act or Old Act?
It is 1994.
Okay.
It was passed under Section 11. Now his new act is 23, my lord. So now, my lord, thereafter it processed, award passed, project affected family was looked into by Deputy Commissioner list. We are the project affected families. Now at that time, the project which was looked into by a company, there was change of the company. Now, when there was a change of the company, they want to look into it. The Deputy Commissioner said, very well, you look into it with these are project affected family. Because ultimately they have to deposit because they are the requiring authority. Now, it was looked into it. Project affected name also, they were happy. But there was a modified, the award was modified because certain components were left out. Left out means by the time it is 2024-25, certain components were left out because they are entitled under RRN policy, Solicium under the new act. All this was given. 2025 it was completed. Thereafter, what has been? They went to Deputy Commissioner and filed a representative for Deputy Commissioner. Look here, how come you passed this award? You could not. We are affected. We also belong. We are also entitled to get compensation. Deputy Commissioner said that it is too late a day because today, 2012, maybe we have modified the award. And thereafter, my lord, his contention was rejected. They said, please refer the matter under the reference court. Your lordship knows 64 is very clear. Any person interested where an award, he is agreed by an award. There is no question of any interested person. They did not receive the award. is under objection. Deputy Commissioner did not refer the matter under 64. They went to the reference court, filed an application under section 64. The court looked into it. Prima facie court said, okay, we'll look into your reference court. Interim direction was given to the Deputy Commissioner to file submission. He filed a written submission before the reference court. Now, their grievance is that the Deputy Commissioner has submitted certain thing against them. That where is the question of right title interest? You are not entitled to get this compensation. Right title interest, you don't have right title interest. They agree by that. Now, we also entered appearance. We told the learned the reference court, look here, we filed an objection on the point of limitation and locus. There doesn't be locus. Now the court said, okay, we'll hear that application on locus and maintainability. In the meantime, main case we'll look into later on. At that stage, they has come to the court by filing a writ petition. Now my point here is, where is that? You go before reference court, maintainability will look into it. Why this court will look into maintainability point? Now he comes to this court, files a writ petition, and the entire matter has been stayed. They want that we should be the amount which was given to us.
No.
And they want to delay this matter.
Matter has not been decided by reference court.
Reference court has not been decided. That's what
Pending.
yes, pending. We don't want any order from this court. Let the order be passed by the reference court. If he is aggrieved by the reference court order, then of course he can come to this court. The matter has not been decided by the reference court on the point of maintainability. It is not the case that Deputy Commissioner has filed a written statement submission against them. That doesn't mean the court will look into the submission which is made by the Deputy Commissioner. The reference court will apply his own mind. My lord, we file a lot of things in the court. The court applies their own mind. It doesn't mean that he will go submission which is made by the Deputy Commissioner. That's my case, my lord. My lord, ultimate, what is the end of the result? End of the result is that your lordship has to send it to the your lordship. With great respect, can your lordship decide the issue?
What relief is his?
Now, you please see, my lord, one thing, my lord. Because maintainability point, which why I am arguing this matter, because court said please look into the first maintainability. I am saying the writ petition is not maintainable at all. Please see, my lord, what is his prayer? Prayer, your lordship will find at page 24. Kindly see his prayer at 24 of the writ petition. On 24. See the prayer. Issue a writ of certiorari, mandamus, or any other appropriate writ order, direction questioning the portion of the respondent number 3 referral letter bearing 9th of June 2025, which falsely asserts that Ampo village does not fall under land acquisition for the Etienne HP, hence not recorded for the land acquisition process, and which declares, see, Janta Umpe, representation dated 18 April 2021 under 64, not maintainable. Issue a writ of mandamus or any direction so and so, deputy so and so to forthwith refer a dispute concerning the apportionment of the components of Akova village to the land acquisition, resettlement in strict accordance with the provision of section 65 of right to fair compensation so and so. Issue a writ of prohibition mandamus restraining the respondent number 3 and 4 from disbursing the component amount or any part thereof in respect of disputed in Akova village, pending the final adjudication of dispute by the competent land acquisition, so and so. Issue 4, issue an appropriate written nature of mandamus, so and so to forthwith forward the petitioner claim reference FRS under section 64 of so and so in due compliance with section 65 of the said act to the competent reference court without expressing any opinion on the merit of the claim or in the question of limitation, and pass such order so and so, so and so. And there was a prayer which they have sought for staying of the proceeding, and accordingly the proceeding was stayed. Now please see, I will not trouble with all this notification because I am again seeing my watch, my lord, only 15-20 minutes. Please see the at page 30 4 negative. The representation of Deputy Commissioner, representation before he has filed for referring the matter under 64.
No, in this case, his prayer for making a reference was allowed.
I'm sorry.
The prayer for making a reference was allowed by the Deputy Commissioner. Matter was referred
No,
to the Deputy.
it was not referred. He went.
It was referred.
1 second. It was, please see.
It was directed by the honorable
The reference
reference court
he went.
to refer the matter.
No,
1 second, please.
this is not the way.
My-
I'll
one
come to
second.
you.
Yes.
Let him submit.
My lord will kindly see at page 304. 204 or 304? 304, my lord. See the annexer 16, my lord. He made the representation to Deputy Commissioner. Kindly see. Pagination, ঠিক আছে না? 304. Lordship, look into 304.
Yes, this is a part of the order.
Yes, no, it is annexer 16.
304 is a
18/4/2025.
second page of the order dated
295, I don't know. It
29/5/2020.
Please see the
Annexure
second,
17.
second copy. I think there was something. Second copy is there with you. Second copy. 1 second. There was something wrong in that. No. This second copy of this. Please.
Oh, no, you have.
Please give the second copy. Second copy. Please is second copy, my lord. I think.
No, these are affidavit.
Line,
No, this is not required.
second copy দেখাবো sir. Second copy 30.
In the writ petition.
In the writ petition 304. No, don't look into the second copy.
Writ petition
Second-
annexure, which annexure? Annexure 17.
Annexer 16, my lord. Please see annexer 16.
Yes, annexure.
Please 18/4/2025.
Page number 295.
295. Sorry, yes, I got it. Now, 295, my lord. Yes, right, 295. No, to move 295 লিখা আছে. Yes. No, ঠিক আছে. 295. 295.
Yes.
My lord, it's 18/4/2025. Lordship got it.
Yes.
Please see representation for withholding disbursement. Who has addressed the DC, my lord? All these petitioners has addressed.
These are the writ petitioners.
Yes. Now, please see. They have said lot of things. Kindly see 307 prayer. 298. Sorry, 298. 298 is a prayer. $298.
Yes.
And see the prayer. 1. Kindly take cognizance of the unresolved dispute between so and so. Withhold the disbursement of compensation to Akova village until such time the dispute is amicably resolved or adjudicated through a competent mechanism. 3. Refer to the reference authority under provision of 64 of right to fair common transparency in the land acquisition rehabilitation. We shall remain grateful for your prompt intervention in this sensitive matter. Correct, my lord? Now, please see at 303 the order of the reference code at 303. 29/5/2025.
Yes.
The present petition is filed under section 64(1) of the right to fair resettlement. Hereinafter, seek direction to the collector deputy commissioner to draw reference in provision containing 65 before this author. So, my lord, their prayer for drawing a reference, that was not taken into consideration. Then they came to the court. Am I right, my lord? To draw to seeking direction to the collector, they have to draw reference in terms of so and so. Heard so and so. Brief facts of the case, plaintiff asserting ancestral and customary ownership of the land so and so.
Who went to reference court?
They filed petitioner, they file. So now kindly say brief facts of the case is that the plaintiff asserting ancestral and customary ownership of land in Akuva village, so and so, contained at the Ambuja Mano clan were allowed temporary sale later encroach upon land. Dispute over compensation so and so arose during the land acquisition process to so and so. Project was revived. Following a circular dated the civil combat disbursement of so and so, and existing so and plaintiff inspected the year-old payment. They specified and modified them, thereby became heir of the final award. Total so and so. This was
Who are the plaintiffs the court is referring to?
the plaintiff, all the petitioners, my lord.
Okay.
Now see, my lord, the cause of action. Please see 304. The cause of action is pleaded as arising from various dates, culminating the DC's failure. My lordship got it? DC's failure to refer the dispute after the plaintiff application dated 18/4/2025. That's why I said DC's failure that came to the day court, to the reference court, following the knowledge of the modified final award. Hence, having seen the petition annexed therein annexed, authorities have considered opinion prima facie, case for reference is made out. The collector deputy commissioner is directed to do reference in terms of provision provided in section 65 for settlement as paid for. So now a direction has been given by the court to draw reference in terms of provision contained under 65 of the act. Am I right, my lord?
Yes.
Now, if your lordship looks into it, let a copy be furnished. So accordingly, this was furnished. And if your lordship looks into at page 28, see place 28. This is reference, referable under 65 by DC at page 28. The court has directed. So according to that, my lord, the submission of referable under section 65 of the Lara Act 2013. Please see 28.
Yes. Yes.
Now, this all has been narrated. What he was aggrieved, I have seen the virtual, what he was narrating before the court. If you see at page 29, please see 29, next page.
Yes.
In screening of all the above fact, it is found.
Last para.
Last paragraph. In screening of the above, the fact it is found that Ampo village does not fall under the land acquisition for the return, hence not recorded for the land acquisition process. Further, the representative submitted on 18/4/2025 by Janta Ompe for the reference on 64 of so and so. It is pertinent to mention period for the claim to be made under section 64 of so and so to award is not maintainable since the land acquisition authority awarded the compensation amount for the Italian project by the award letter dated 28th of June 2015, dated 6 to 16th of December 2015, and approved by the government later dated so and so 2019 and 8 February 2018. So this is what this submission was made. Now thereafter, if your lordship turn to page 306 again, please see 306. 306.
Yes.
We appeared because we are the project affiliate families. Page 306. Please see the order of 1/7/2025 before the reference court. Lordship got it? 1/7/2025.
Yes. This is after reference made by the deputy commissioner.
Correct, my lord. In pursuance to the court's order.
Okay.
Now see at 1/7, learned counsel appellant so and so is present. We, my lord. Learned counsel P. Tafo, the present Miss case is filed seeking preliminary objection to maintainability of reference case on two grounds, that is on limitation and locus of response to seek reference. Issue notice. Notice is returnable on next date. Since Genie has accepted notice, respondent shall file reply, if any, 15 days before next date, fixed and copy shall be furnished. On the next date, fixed endeavor shall be made to hear the Miss case. List the matter on 11/8 for hearing so and so. Now, at page 307, on 1/7/2025. It is the main case. The respondent number 1 has filed civil miscase. Got it, my lord? On 1/7 is the main case. Filed civil miscase number so and so. The learned counsel for the appellant is present. The matter is suspended till disposal of the
Civil miscase before which court?
before the reference court itself. My lord, there was the main case. We said, please keep this main case in evidence here on the point of maintainability and the locus.
Limitation.
Yes, limitation. Court said, okay.
On that basis, on basis of that petition, this civil miscase was registered.
Yes, correct. So now he has come against whole order. He has come against the whole order, and he has come against the filing of the reference court himself. And Deputy Commissioner has referred under 65 as per direction of this court. What we are before this court, my lord, this matter has to be adjudicated with great respect by the learned reference court, not by this court, my lord. It's a small matter, my lord. This matter may be remanded back to the reference court to decide the issue of maintainability locus. If the court may say, yes, you have a maintainability, they have a locus, the end of the matter. If they are aggrieved by that, they are open to come to the court. Why at this stage the entire matter has been stalled?
No, against reference court order, appeal lies.
That is one point, my lord. I don't want, that's right. Now, please, my lord, whatever may be, we will take this point. Because the matter, that is another point where appeal lies, under 64. We are not going into that point also. We are saying, let the matter be decided by the reference court on the point of maintainability. My lord, on this ground, if you see 64, please see 64. My lord, I didn't want to trouble the whole bunch. I didn't want to trouble this because your lordship now know this matter is a very narrow campus. Is a very narrow campus. Your lordship don't have to lead the end.
No, why writ petition is not maintained?
Yes, please see. If you see why it is maybe at one, it will maintain. Why, my lord will kindly see, if your lordship looks into 64, because it is, why it is, my lord, writ petition to my lord, if you see 69, please see 69. 69 of the right to fair compensation. Please see 69. First see 69, my lord. Just I'll give an answer to it. Why an appeal? Your lordship has said, please see 69.
Yes. Yes.
See 69. Determination of award by authority. In determining the amount of compensation to be awarded for land acquired, including the rehabilitation and resettlement entitlement, authorities shall take into consideration whether the collector has followed the parameters set out under section 26 to section 30 and the provision under chapter 5 of this act. Right, my lord?
Yes.
Now, if you see now that 2, 3 is, now C is 74. C74, appeal to High Court.
Yes.
The requiring body or any person agree by the award passed by an authority under section 69 may file an appeal to High Court within 60 days from date of award. Now what 69 says? It says determination award by authority. Now what it says, whether the rehabilitation, the authority shall take into consideration whether the collector has followed the parameters set out under section 26 to 30. Here, my lord, the award was passed by whom? It is passed by the collector.
Yes. No, they could have approached this court in appeal only against final order made under 6.
This is one, my lord. What I am saying that one, it is at a stage, very initial stage. before the reference court.
Suppose they are agreed with an.
No, we agree, that is different. Then if they are agreed,
This is my query.
yes.
They are agreed with an order in the reference proceeding.
Yes.
What is the remedy available to them?
The remedy, maybe, my lord, if they are agreed from some procedure, then they may come up by filing a writ petition.
That they have
If it is a final order, against a final order, then the issue is different, my lord.
against final order appeal lies.
Yes. Now, if you see, my lord, that is also, if you see 64, see 64. But reference to authority, also 64, kindly see.
Yes.
See the reference to authority. Any person interested who has not accepted the awarded may by written application. 64.
Yes.
Any person interested who has not accepted the award may by written application to collector require matter be referred to the collector for determination of the authority as case may be, whether is objection, measurement of the land, amount of person to whom it is payable, right of so and so among the person interested. Now, why we said that he doesn't have any locus before the learned reference court? Because if your lordship looks into it, it is not, he is not any person interested who has not accepted the award. There is no question of an award which has been passed by collector. We are the project affected families. We belong to the village where it was acquired, which is known as Akoba village. So this is absolutely, we also have a doubt whether this is what we are raising this point before the learned reference court.
And he hails from which village?
He is been from Ampo village. It's totally a different village.
That land has not been acquired.
No, it has not been acquired. He is saying some story and saying, no, he belongs, my lord, what my submission is all this is before the reference court. All these issues are before the reference court. So my respectful submission before this honorable court, let the reference court decide all the issue. Let the reference court decide all the issue. Why? Ultimate end of the day, what your lordship will remand the matter before the reference court. It is not that finally your lordship will say that no, what we'll do, we'll pass the yes, award may be passed in their favor. That of course your lordship will not decide. The only decision that has to be taken before the he has got lot of opportunity, let him go. He comes to the court, says the entire proceeding. Why is staying the entire proceeding? What is the intention of staying? And your lordship knows this award is of 2015. We are the project affected families.
Till now, you have not received.
No, that's why we file an application. Last time when we submitted before the court, pending will not be a bar. Court said you file an application before the court. No, what we are saying, my lord, if the court decides, if the court sends back to the learned reference court to decide the issue on the limitation and locus, that is the end of the matter. They will get all the opportunity to object before the learned reference court. So that's a small, short point. I didn't want to trouble with voluminous saying that these are Ampo village, these are Akoba village.
Yes.
This is why I'll trouble. But at the end of the day, my lord, see what is the matter about. The matter is a short point, is on the point of maintainability. Whether writ petition is maintainable or not. That's the point.
Yes. What is your submission? Anything else? You have anything else to submit?
That's all.
Yes.
I don't want to open the history of the case, my lord.
You have already approached the reference court.
Plus, that is correct, lordship.
Reference court, they have raised a plea of maintainability of the reference.
Lordship, I am being aggrieved by the referral applications that was filed before the reference authority by the Deputy Commissioner, Lordship.
This question,
Is shown, Lordship.
this question you may raise before the reference court.
Lordship, that very questions which we ought to have been raised, Lordship, and the learned respondents, they are raising that same issue. The answers are there in the referral applications of the Deputy Commissioner, Lordship. Now that very, Lordship may kindly come to page 29 of the referral applications that is been filed by the Deputy Commissioner before the reference authority, Lordship. I am being aggrieved by this very order passed by the Deputy Commissioner, Lordship. Now, whether this particular paragraph that has been cited, Lordship, whether that this kind of order can the Deputy Commissioner pass while referring the application under Section 65? That is the query, Lordship, that has to be addressed by this
No,
Honorable Court.
you make your submission first to the reference court, that if something is mentioned in the referral order by the Deputy Commissioner, which is not in consonant with Section 65, you bring it to the notice of reference court. It will decide.
Lordship, what had happened in this case is, Lordship, since learned senior counsel has also made the submission saying that we made a reference before the Deputy Commissioner. Deputy Commissioner was not referring that matter to the reference
Ultimately,
authority.
now it has been referred.
Ultimately,
But
it has
with
been
some
referred,
observation,
but with certain observations,
which
is detrimental for adjudication of the
you
matter
satisfy
before
the
the reference court.
that this should not be taken into consideration.
So why I am seeking direction from this honorable court, Lordship,
Why?
that particular portion should not be referred by the reference authority, Lordship. That is barred by law, Lordship. The Deputy Commissioner cannot adjudicate, well, referring that matter, cannot make certain observation on this ground, Lordship. Cannot decide that here, Lordship, the Deputy Commissioner has decided the title itself, Lordship.
No, Deputy Commissioner rightly or wrongly has made an observation that this land was not acquired. And secondly, that the award was made 10 years back. These two observations were made.
Lordship, that very point which is raised by the respondent sides regarding the maintainability of the reference matter before the reference authority, that has been addressed by the Deputy Commissioner, Lordship. The matters ends there, Lordship.
No, you satisfy the.
Now, I have an apprehension that this very observation will influence the reference authority. Definitely, it will influence, Lordship. So I am agreeable. Now, as per law, Lordship, the Deputy Commissioner cannot make such observation, Lordship. They are barred from making such observation, Lordship.
Where is the bar?
Lordship, I have a citation, Lordship. I'll just place the citation, Lordship.
Yes, Mana say itu? Judgment to?
That is 1966 AIR SC 237.
Mana? 6. Yeah. AI 1996.
1966. AIR SC 237.
237.
What is the matter here?
237.
Lordship, paragraph 19, last paragraph, Lordship, I have just marked it, Lordship. The collector has no power to finally adjudicate upon the title to compensation.
No, no adjudication has been made by the collector. Collector has given a statement of fact only, which may be relied upon, or if contrary evidence is produced before the reference court.
Lordship, that small observation is coming forth from this honorable court, Lordship. If the matter is remanded back, Lordship,
no,
we also want that the matter has to be adjudicated before the reference court.
Remand does not arise. If the writ petition is not, because matter is still pending before the court, reference court. Let the reference court decide the question of maintainability.
Correct, Lordship. But then this particular observation that has been made by the Deputy Commissioner, that should not be relied upon, Lordship. So I am hesitating before this honorable court, Lordship.
No, ultimately, suppose court finds out that the statement made by the Deputy Commissioner is in fact true, then there may not be any bar to rely. If you fail to adduce any contrary evidence, contrary material, then court may rely. But now Deputy Commissioner has not adjudicated anything. He has,
That is correct, but this particular observation, it would highly prejudice the petitioner lordship while adjudicating the matters before the reference court lordship.
where is section? The paragraph 19, what it says. No power to finally adjudicate.
Yes, lordship. Now here, as per this observation, finally he has executed the title itself, saying that lands does not belong to me, lordship. But the facts of the case is otherwise, lordship. Now he clearly says that land that has been acquired, that land does not belong to me, lordship. So finally he has adjudicated the title itself.
Anything else? Anything else on the question of maintainability?
Question of maintainability regarding that limitation, lordship, that will agitate before the reference court, lordship. If lordship is taking up that regarding that, lordship, I can make my submission, lordship. That very issue regarding the limitation.
No, the plea of the learned counsel for the other side is that as the matter is pending before the reference court.
Lordship, we also want that the matter has to be heard before the reference court, but we want that the observation that has been made by the Deputy Commissioner that should not be referred by the reference authority, lordship. This has to go, this particular paragraph has to go, lordship. Under section 65 of LARA Act also, lordship, specifically the conditions are there, lordship, how the reference has to be made, lordship. There are nothing as such, the observation that has been made here in the application, those observations are not sought in the section 65 of the LARA Act, lordship. Now he is exceeding his jurisdiction also, lordship, by making such observation, lordship. So we are agitating, lordship.
No, but 65A says the situation and extent of land, the particulars.
How the reference has to be made, lordship, that is there in the section 65 of LARA Act, lordship.
Anything else?
Here, lordship, section 65, lordship may see, lordship. Collector's statement to the authority. In making the reference, the collector shall state for the information of authority in writing under this hand, the situation and extent of land with particulars of any trees, buildings, standing crops thereon, the names of the person whom he has reason to think is interested in such land, the amount awarded for damages and paid or tendered under section 13, and the amount of compensation awarded under section provision of this act, the amount paid or disputed any other provision of this act, if the objection be to the amount of the compensation, the ground on which the amount of the compensation was determined, the statement under subsection 1 shall be attached to schedule giving the particulars of notices served upon and the statement in writing. So here is the particulars how the reference has to be made, lordship. Now he cannot exceed beyond, go beyond this, lordship.
That is one submission.
Lordship.
Anything else?
Lordship may kindly come to page 32, lordship. This is form 6A, lordship. This is part of the referral application submitted by the
Deputy Commissioner.
Deputy Commissioner.
Yes, what you want to show?
Abstract of the statement, Lordship. May kindly come to the abstract of the statement. That here, Lordship, Deputy Commissioner, he himself agrees to the fact that the matter is disputed since long, Lordship. Kindly take cognizance of the unresolved dispute between the Sitomelo clan and Ambuji Mano clan of Akobe village in relation to entitlement and apportionment of compensation amount. It hold the disbursement of compensation to Akobe village, serial number so and so, until such time the dispute is amicably through a competent mechanism. Refer the reference authority under the provision of Section 64 of Lara Act 2000 as the sought in the said representation memorandum. However, the claim had been made by the Sri Uchi Umpe, who is one of the petitioner here, Lordship, and Lame Mihu in so and so for enlistment as interested person, Lordship. Lordship, we have been agitating since 2014, Lordship, for enlisting ourselves as one of the beneficiaries in the beneficiary list, Lordship. That has been rightly been acknowledged by the Deputy Commissioner, Lordship. The title regarding the disputed land, Lordship, it's already there before since
Okay,
2014.
Yes, Mr. Das.
Yes, I'm sorry.
His main objection is that the observations made by the Deputy Commissioner while making reference on this was beyond what is required under Section 65.
Correct, Lordship.
So same should not be taken into.
But that he can make a plea before the learned reference court.
Yes.
That this whatever submit referral under 64, this is, he can raise
You have
objection
not-
there.
You have not,
He has, my
not
lord,
raised this before.
my lord, lot of things, my lord, we file lot of affidavits, reply has been also filed,
Okay.
but ultimately court has to look into it.
Yes.
See, court has not looked into it. Court may say that, yeah, this is not tenable.
Whether you have raised this.
All this
before
point,
the-
Lordship, we haven't raised
no,
because,
that he is not raised.
because
Straight away he will
before
come.
before the next that hearing, this very application was furnished to us. The Section 65 application that was forwarded by the Deputy Commissioner. This very we applied for the certified copy of the same and we were furnished, Lordship. So after looking into this particular paragraph, I have directly rushed before this Honorable Court, Lord.
My lord, can the one thing, but subject to your lordship approval, he has got some urgency. We have also got urgency. Let a direction be passed to the reference court to decide the matter within a period of 1 month. Let it be decided. The maintainability point, let it be decided. Let me decide. That's the best. Let him decide on that point. He wants the matter. We also want. Let it be decided. He can, my lord, he has not raised this point before the reference court. Maintainability to Section 65, he has never raised this point before the reference court. Straight away, he has come to this court and he is now raising this point. When the matter is being pending now.
Okay.
Lordship,
Yes.
I have come before this Honorable Court. Why? Because Lordship, the Deputy Commissioner, Lordship, he has exceeded his jurisdiction, Lordship, under Section 65. So why am I agitating, Lordship?
Okay, heard Mr. B. Picha.
J. Gini, Lordship.
What is your name?
J. Gini, Lordship.
J.
Gini,
J. Ginny,
Lordship.
Learned Counsel for the petitioners. Also heard Mr. D. Das, Learned Senior Counsel, assisted by Mr. K.
Muhammad and Aidas.
K. Muhammad and I. Das, Learned Counsel for the respondent number.
I am private respondent. He is my learned friend.
I will be appearing for 1, 2, 4.
And we are from 5 to 10.
Learned Counsel for 5 to 10. Also heard
Mine is 5 to 10, my lord.
before that, I also heard Mr. M. Ratan, Learned Additional AG, appearing for respondent number 1,
2, 4.
2, and 4.
1, 2, 3, and 4.
1, 2, 3, and 4. It appears from record that on 25/2/2026, the learned senior counsel for, you have submitted any written
Yes, we filed.
raising the issue of maintainability,
Yes, we filed. Reply we have filed.
wherein you have raised the issue?
Yes, yes. So.
What was the last name? Appears from record that on 25/2/2026, learned senior counsel appearing for respondent number 5 to 10 had raised the issue of maintainability of the instant writ petition. So up to that effect,
My lord, my learned friend also has
We have
raised.
also raised this.
on the same ground.
Same ground.
And, la- la-
State as well as.
continue. The learned additional AG representing the state respondent, as well as learned senior counsel representing the private respondents, raised the issue of maintainability of this instant writ petition. It also appears that to that effect, an affidavit in opposition has already been filed by just where is the objection? Ray?
Madam, in our affidavit, madam. Affidavit in opposition. Preliminary objection at page 422 of our affidavit. Filed by the respondent number 3 and 4.
To that effect.
Page 422. My page in it is 422.
To that effect, the state respondent in their affidavit in opposition has also raised preliminary objection regarding maintainability of the instant writ petition. Learned senior counsel for
Paragraph
the
16, my lord.
Our,
Mine is paragraph 16.
our
page number.
Page number 318. For a last line.
P one eight.
318.
Yes.
318 last line. In such a contention, is such a content maintainable is another question. Narrating the entire thing. Lordship got it?
Yes.
But in the reference code, is the order passed by the court. Reference, see the reference, the order. The reference order. Para 33, also in my petition, 33 window, no, 33. Page, my lord, kindly see para 328. See, first 328, my lord. See 328, my lord, of my affidavit. Yes, 328. I'll just read that. 328. Yeah. See page 328. I'll read
No,
down.
no, basically submission.
No, I'll just, this everything is here in 328. Please see 328. Para 33, my lord.
Yes.
I just read that a petitioner submitted representation dated so and so dispute pertaining to Ampu village in connection to instant hydropower project. According to district admission by clarification dated 11 January 2020 stated land acquisition proceeding of so and so has been completed. All the process laid down as per rules and guidelines. Thus, there are series of admission process with substantial. Ampu village does not come into picture in land acquisition process. Hence, this honorable court may be pleased to dismiss this petition in the interest of the as this being the fit case to be dismissed on the ground of maintainability. 34-35 also. It is applied this upon reference made by instant learned court below by civil revenue director draw reference in terms of according deputy commissioner drawn a reference that the petitioner come before this court find this before this suspending the proceeding before the learned court. 35. The present petition is liable to dismiss at the threshold on the ground of maintainability alone. Lordship got it?
Yes.
35. 36 also same, my lord. 36, please 36. The present petition is liable to dismiss at the threshold on the ground of maintainability alone. 36. $35. Lucas Tandy, everything at 35 kindly see it is written, my lord. Present petition liable to dismiss a threshold on the ground of maintainability. The petitioner has failed to make out any cause of action warranting interference of this honorable court and the issue raised fall outside the permissible scope of proceeding under the present jurisdiction. It is submitted. Petitioner suffers from fundamental defects including lack of locus standi, absence of statutory compliance and non-fulfillment of essential prerequisite mandated by law. In view of this infirmities, present case does not merit consideration on merit as the fees to be dismissed solely on the ground of maintainability. I think it's a very clear, my lord. We have raised the point of maintainability. 36 also is there. Few paragraphs on the point of maintainability. And
it appears from record that ... This I will dictate later on. Stop. Learned senior counsel for the private respondent, Mr. D. Das, has submitted that the present petitioners, before approaching this court, had approached the reference court, that is the court of learned. Which court?
Before district court, district judge, East Station Division, Teju.
London District Judge East
Station
Division, Teju.
Wait, at page 306.
Teju, by filing an application under section 64 of the right to fair compensation and transparency in land acquisition, rehabilitation and Resettlement Act 2013, praying for a direction to the Deputy Commissioner. Which Deputy Commissioner?
Anini Divangveli.
Deputy Commissioner Anini, to draw a reference in terms of section 65 of the 65 of the LARA Act 2013. He further submits that accordingly, by order dated 29/5/2025, passed by the LAAR authority in civil reference case number 3 within bracket DV slash 2025. The Deputy Commissioner Anini was directed to draw a reference in terms of the provisions contained in section 65 of the Act of 2013. And accordingly, on 9th June 2025, the Deputy Commissioner Dibang Valley District, Anini, had drawn up a reference under section 65 of the said Act. It is further submitted by learned senior counsel for the respondents that the respondents, the private respondent here too, appeared before the reference court and on 172 and filed an application before the said court raising the issue of maintainability of the reference made by the Deputy Commissioner on the grounds of limitation and locus standi of the present respondents to seek reference. The said petition filed by the present private respondent on the basis of the said petition filed by the present respondent, the civil miss case number 23 within bracket DV slash 2025 was registered and notices were issued to other sides. It also appears that 15 days time was granted to the respondent side in the said miss case to file written objection, and the next date of hearing was fixed on 11/8/2025. It also appears that the reference case number 3 within bracket DV slash 2025 was also stayed by the reference court by its order dated 1/7/2025 during the pendency of the civil miss case number 23/23 within bracket DV slash 2025. Learned senior counsel for the private respondent has submitted that when the reference court was seized with the matter regarding maintainability of the reference made by the Deputy Commissioner in the civil miss case number 23 within bracket DV slash 2025, and an opportunity was granted to the present petitioner to file written objection. You have not filed any written objection.
Oh, my lord. No, they have not filed.
In the miss case.
I don't know whether they have filed or not.
No, we have not filed yet.
written objection, and the present writ petitioner could have raised any objection regarding the plea of maintainability raised by the private respondent before the reference court. Instead of doing so, they have rushed to this court. Taking invocation of writ jurisdiction, which, according to learned senior counsel for the respondent, is uncalled for in the facts and circumstances of this case. He further submits that as to whether the reference made by the Deputy Commissioner after the order dated 29/5/2025 passed by the reference court was in terms of the provisions contained in section 65 of the LAR Act 2013 or not, could have been well agitated by the present writ petitioners before the reference court, instead of raising the said issue before this court. On the other hand, learned counsel, Mr. T. Gini, Mr. J. Gini, learned counsel for the petitioner, has submitted that in the instant writ petition, the petitioners have challenged the entire proceeding.
Not entire proceeding, Lordship. The reference applications that has been
Challenge the
filed by the Deputy Commissioner, Lordship.
Challenge the
Page 28, Lordship.
challenge the referral order made under section 65 of the Act of 2013 by the Deputy Commissioner, in as much as in the paid referral order, the Deputy Commissioner has made certain observations which were not mandated under section 65 of the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. He submits that the observations made in the referral order by the Deputy Commissioner to the effect that Ampo village does not fall within the does not fall under the land which has been acquired for ETAIN, ETAIN, ETAIN HEP within bracket 3097 MW.
Lordship, it has to be Italian, Lordship. L is missing here, Lordship. ALIN.
ALIN, Italian H. Is uncalled for and would if it is allowed to remain, it would certainly have an impact on the reference court while considering the question of maintainability raised by the private respondent before the reference court. He also submits that the deputy commissioner could not have finally adjudicated upon the title of the present petitioners and made an observation to that effect in the referral order to the reference court. Stop. Any other submission?
Lordship, he has in this very order, Lordship, he has decided the issue regarding the limitation under section 64 also, Lordship.
It is also submitted by learned counsel for the petitioners that while making reference to the referral court under section 65, that too in pursuant to the directions of the court, the deputy commissioner has also exceeded his jurisdiction in stating in the referral order that the claim made by the present petitioner under section 64 of the Act of 2013
is not maintainable.
Is not maintainable. Stop. I have considered the submissions made by learned counsel for both the parties. It appears that the petitioners herein are mainly aggrieved with the observations made by the deputy commissioner in the last paragraph of the referral order, by which reference under section 65, referral order dated 9 June 2025, by which the reference under section 65 was made to the reference court. Stop. It also appears that the plea of maintainability of the aforesaid reference proceeding within bracket reference case number 3 within bracket DV/2023 has already been raised by the present private respondent before the reference court, and on this basis of the paid application filed by the present respondent, a civil miss case number 23 within bracket DV/2025 has also been registered. It also appears that, what is the date of filing this writ petition?
Lordship, 6th August 2025, Lordship. Page 27, Lordship.
It also appears that the said miss case, within bracket miss case number 23 with DV/2025 was fixed for hearing on 11th August 2025, and the present petitioners were afforded opportunity to raise objection by filing a reply to the petition regarding petition filed by the present respondent raising the question of maintainability. However, instead of raising their concern before the referral court, the petitioners approached this court by filing the instant writ petition on 6th of August 2025, and thereafter by order dated, when it was stayed,
7th August.
by order dated
7th August.
7th August 2025, this court had stayed the entire proceeding of civil reference case number 3 within bracket DV/2025, as well as civil miss case number 23 within bracket DV/2025. Stop. Since on perusal of the materials available on record, and after considering the submissions made by learned counsel for both sides, it appears that the reference under section 65, referral order under section 65 of the Act of 2013 was made by the Deputy Commissioner. What is the district's name?
Dibang Valley, Anini. Anini
Deputy
Dibang.
Commissioner, Dibang Valley District, Anini, in pursuant to the order dated 29/5/2025, passed by the reference court in civil reference number 3 within bracket DV/2025. Stop. It also appears that though in the referral order, the Deputy Commissioner has referral order dated 9 June 2025, Deputy Commissioner has made an observation regarding maintainability of the reference under section 64 by the present petitioners, however, this court is of considered opinion that same is not binding on the reference court, and reference court may or may not take the same into consideration. And it may decide the question of maintainability raised by the present respondent before it on the basis of materials on record. It also appears that the present petitioners could have raised any such issue which they have raised in the instant writ petition before the referral court while filing objection against the petition filed by the present respondent raising the question of maintainability. Since the reference court within bracket LAR authority has not yet decided the question of maintainability raised by the present petitioner, present private respondent before it on the ground of on the ground of locus standi of the
limitation.
petitioner as well as on the point of limitation. And since the observations made by the deputy commissioner in the last paragraph of the referral order is not binding on the referral court, this court is of considered opinion that the petitioner do not have any cause of action to approach this court at this stage by invoking its writ jurisdiction. Accordingly, the petitioners herein are relegated to the to approach before referral court by filing their objection against the plea of maintainability raised by the private respondent, if they so desire.
My lord, kindly fix a date within a period of 1 month. It should be disposed of, my application.
And
That should be upon the discretion of.
No, it's not discretion. They will take time after time, my lord. Let it.
Referral court is.
Why should I wait?
Yes.
Is directed to decide the question of maintainability of the reference made to it by the deputy commissioner on application of the present respondent within as expeditiously as possible, preferably within a period of 2 months
It's okay, fine.
from the date of this order.
Reply on
This with above observations, this writ petition is disposed of.
Right. I'm not pressing the IA.
In view of the disposal of the writ petitions, the connected IA stands closed.
Yes. Reply, please.
Obliged.
Item number 12.
May I please, my lords? My lord, I appear for the petitioners in this matter. Notices have been issued and 3 weeks' time was granted. However, only respondent number 7 to 11 and 14 have filed their responses. Respondent number 1 to 6, primarily the government officials, and respondent number 12, 13, 15 to 28 have not filed their responses. despite adequate time being given to them.
No, my lord.
If
In
your lordship,
respect to
if your
respondent number
lordship,
16, my lord, I am appearing entrance today. I'll file my wakalatnama by tomorrow.
Respondent number?
16. The first time I'm appearing.
may I take my lords to order dated 2nd of February 2026.
Yes. Respondent number 16.
And there are various other respondents, my lord. We don't know whether services are complete or not.
Can I take my lords to order dated
Well,
2nd of
I am-
February?
Well, I am appealing for respondent numbers 17 to 26. And I pray for my lord 4 weeks time to file the affidavit in opposition.
Lords, may I make my submissions before my learned friends make their submissions?
Yes.
We are entering appearance only to them, my lord.
Yes, what is your
We will have to
submission?
file our affidavit.
Here the
I'm ready
screen
for
is so below.
I wish to invite your lordship's attention towards order dated 2nd February of this court. Am I audible, my lord?
Yes. It can be little lowered, slightly lowered. Yes, okay, it's okay.
Lords, I am
Yes,
reading.
now you are audible and visible.
Thank you so much, my lords.
Yes.
This is the order dated 2nd of February 2026. Heard
Yes.
Shri so-and-so, learned counsel appearing on behalf of Mr. So-and-so, learned counsel for the petitioners. Also heard Miss R. Basar, learned state counsel for the state respondents number 1, 3, 4, 6, 12, 13, 14, and 15. And Mr. K. So-and-so, learned counsel for respondent number 17 to 26. Office note dated 31st of January 2026 indicates that service in respect of respondent number 16 has been received back after causing service. However, the service reports in respect of respondent number 5 and 27 are still awaited. It is noted that as per the postal tracking delivery report, notice upon respondent number 5 and 27 has been duly delivered on 9/1/2026. In view of the above, services upon respondent number 5 and 27 are deemed completed as prayed by the parties. Fix it for 3/3/2026. Now, my lords, my request to this honorable court would be the following. If your lordships can consider the interim prayer, which is not going to harm anybody's interest. If your lordship would have page 40 of my petition.
First, the question of interim prayer at this stage, my lord. My lord, we see the first order. The question of maintainability has been left open. My lord, let us respond, my lord, then thereafter it may be heard.
That issue has already been crystallized by this honorable court's order dated 25th of October 2025. The question of maintainability is only qua form and style, which is left for consideration and which, my lords, will have to be decided along with the main petition, for which notices have been issued. If your lordship permits me, I will read the order dated.
In any case, my lord, we have to respond, my lord. We are entering appearance today, my lord.
What is your interim prayer?
My lords, my interim prayer is very simple. It's not going to hurt anyone. If your lordship would just consider page 40. In the interim, direct that the respondent number 1, 2, 3, 4, 5 to dispose of representations dated 29/5/2025, complaint dated 1/8/2025, and memorandum dated 12th of August 2025, in accordance with the procedure laid down by the apex court in Kumari Madhuri Patil and another. Because the law in that regard is crystallized after Madhuri Patil, constitutional bench has also reaffirmed the Madhuri Patil procedure. That's all my
What it says? What it says?
It lays down a procedure for determining who can be considered as a scheduled caste and who cannot be considered as a scheduled caste. It's a detailed procedure laid down by the apex court. So I'm not asking for something which is new. I'm only asking the state authorities to dispose of my application as per law, which has been laid down by the Supreme Court. That's my limited prayer. I don't think anybody should have any problems with that.
We have lots of
And then
problems. It cannot be that somebody will just come and just say that, oh, you are not ST, you are not ST. What is this, my lord? Let us respond, my lord. Let us respond.
Let us file the affidavit in
we can't
opposition.
overrule-
What the interim payer, my lord, is also
But
akin to the
we
main
can't
payer. What he
overrule
has
the
made.
Supreme Court sitting here. My learned
The
friends,
interim payer, my lord, is as
Don't
good as the
misinterpret
main
the
payer
judgment
that
of
has
the Honorable
been made.
Supreme Court.
Lordship will kindly see the main payer, that is reflects what the interim payer is, my lord. And at least let us respond, my lord.
Yes.
No, his prayer is only for disposal of the.
No, my lord, that cannot be, my lord. Kumari Madhuli
Same
Patil,
thing,
my lord.
same prayer in the main payer.
So, my lord.
That is the prayer.
That is the prayer.
No. I'm sorry.
And let us-
I'll read other prayers also, if your lordship pleases. Page 37. There
No,
are many
let
other
them.
prayers. There are about
You will be filing your affidavit.
Yes, affidavit, my lord.
How much time?
4 weeks, my lord.
4 weeks, my lord.
Look, 3 weeks have already been given.
And there's
Now,
no urgency also, my lord. The ST status has been granted, certificate has been
weeks.
issued, my lord. What is there to be, my lord, cancelling within a day, my lord?
fraudulent. Every single day they are usurping the money which belongs to the tribal population of the state.
First of all, the
Every
petitioner has to
single day.
establish what is his interest, what is his locus, because that has to be, my lord. Therefore, the
Oh,
petition is not
okay.
maintainable
No,
and
no,
this has
I
to
am
be
giving
included in the
some.
money orders.
I am giving some time. Heard Mr. B. Sibo, learned counsel appearing on. What is your name?
Mahmood Pracha, my lords.
Sorry. Heard Mr. Mahmood Pracha, learned counsel appearing for the petitioners. For sole petitioner,
No, my lords. There are
for the petitioner.
5 others.
5 others. 5 petitioners.
Also heard Mr. Who is state respondent? What is your name? Why? Why Riram? Riram. Learned Government Council appearing for state respondent number 1, 3, 4, 6, 12, 13, 14 and 15. Also heard Mr. P.J. Soikia. No, also heard Mr. D. Panging appearing for respondent number 16.
I'm entering a page today.
Who submits that he has filed his Wakalatnama today and prays for
I'm praying for 4 weeks.
4 weeks' time for filing affidavit in opposition. Also heard Mr. P.J. Soikia, learned senior counsel assisted by Mr. P. Bortole, learned counsel for the respondent number 17 to 26, who also prays for some time for filing affidavit in opposition. It appears from record that in notices issued to respondent number 5, 5 and 27 have already been held to be duly served by order dated 2/2/2026. Though Mr. Pracha, learned counsel for the petitioner had
Petitioners,
prayed
my
for,
lords.
petitioners has prayed for grant of interim relief prayed for by the petitioner, in the meanwhile, by directing the respondent number 1, 2, 3, 4, and 5 to dispose of the representation dated 29/5/2025, 1/8/2025, and 12/8/2025, in accordance with procedure laid down by the Apex Court in the case of Kumari Madhuri Patil and others versus Additional Commissioner, Tribal Development, however, considering the fact
Mulaj, may I just interject? I hate to, but there is a previous order of 25th of October, which clearly says that interim application will be considered on the next date of hearing. That is order dated 25th of October 2025. If your lordship would have.
25th,
21st of October 2025. The first order, my lords. Regarding the prayer for an interim order, this may be considered in the next date of the listing. So therefore, I'm only requesting a shortest possible date may be given, and the last opportunity may be given to them if they want to file their opposition. That's all my request.
what was the last line? Last line. However, considering the fact that the respondent who has raised the question of maintainability?
But we'll also raise balance.
Respondents have.
Well, it's only on two counts.
The court
form and
order
style.
itself saying.
No, the court order says only form and style. No other locus or otherwise.
Which order?
21st of October 2025. Second
The
last.
question of maintainability is always open to us, my lord.
But that's true, but it can be decided at the final because on the first date of hearing, this thing came up.
Final or whatever, we'll file our affidavit, the lordship will take a call.
Okay. Okay. Have you done with your quarreling amongst yourselves?
No, my lord. He's saying something, that's why I'm responding, man. With greatest respect.
I'm only pointing out the previous orders. I'm doing nothing else.
What was the? However, considering the fact that that question of maintainability of instant writ petition in present form and style has also been raised by the respondents, this court intends to give opportunity to the respondents to file their affidavit in opposition by next date. List this matter.
Sir.
After 3 weeks, give a date.
26th.
Date to sir.
26th of March. Is it okay?
My lords, I'm deeply
That's not
obliged.
difficult. This man.
I'm deeply obliged, my lords.
26th of March.
Item number 13.
I'll just. I'm not troubling with the hearing of this matter. If your lordship looks into, there is an order which is passed by this court on 5th of 5 to 2026, my lord.
Item number 13.
5 to 2026. Order, item number 13. Hearing will take place, will take time. Only just see, I'll just point out. Because it is a land acquisition matter, my lord.
Keep this with the yes, where I should order. Today, this petition has been disposed in that.
Simple, you're right. I mean, restore it,
Yes, order dated
5 to 2026. Got it, my lord? 5th of February 2026.
Yes. Yes.
Expressed some urgency and has referred to the order dated 19/12/2025 of this court. 19/12 also. So and so prays for time to obtain up-to-date instruction with regard to status of the work, which is a subject matter of acquisition proceeding. Release this matter on 11/2/2026. Matter was posted on 11/2026, but paucity of time, the matter could not be taken. The matter was being listed. So the court said that you can make a mention out of turn before the court. I think if I'm not wrong, my lord. That was the order that was passed on 11th of February 2026, my lord.
Yes.
Now the question here is that, my lord, short, it is a land acquisition matter. In there are three packages: package 1, package 2, package 3. We are concerned about package 3. It is in respect of making lane, highway lane. So it is package 3. Now in package 3, there is no notification for acquisition, and our land has been acquired. This is our contention of the contention of this entire matter. That you have acquired the land without any notification, and this is my land. There are few letters, the past few letters in the writ petition, where it indicates that yes, the forest, the DC has wrote to the forest department also, stating that yes, whether 340 you issue a notification. Now in that notification, if your lordship looks into the order of 9/12/2025, please look into 9/12/2025 order. 9/12. Lordship got?
Yes.
Please see this, my lord. Hard Mr. Barbara Larned, Senior Counsel, assisted by so-and-so, who submitted petitioner, the resident, these are the petitioner, are resident of different village under the Tideng region, where they have been resided since the time of their forefathers, and they are aggrieved for being excluded from amongst those to receive compensation for the construction of national highway, particularly in respect of alignment of only so-and-so package 3. According to the petitioner, the surrounding areas were initially proposed for declaration as reserved forest area by notification dated 13/12/1977. However, by excluding an area of 50 square kilometer earmarked for the use of the villager, said notification only a proposal and has not culminated into a declaration for reserved forest. That in fact 50 square meters has been excluded from the proposed area of declaration reserved forest, since the same is being used by the villager. It is a case of the petitioner, they are residing within this 50 square kilometer area, but despite the same, the DC Lohit district wide impugn notice dated 4/7/2025, Annexure 25, which your lordship will find at page 259, and impugn circular dated 5/9/2025, which is at page 389, has notified there will be no, it is not exceeding, it will be no existing alignment of the only so-and-so package 3 so-and-so, as it is a greenfield without any habitation settlement, and that the same will be excluded from the acquisition process and no compensation will be paid. Now this is important. Learned Senior submit the same in fact runs counter to the information given by DFO, Lohit Forest Division Teju to DC, Lohit District on 21/2/2025, which you will find at page 208. He submits, as per the said letter of the forest department, has no objection for acquisition of the land subject to the consent of the affected villages, since the area is excluded from the Dalai proposed reserve forest for use of the villager. The Learned Senior Counsel there submits impugn notice and circular shall therefore be set aside, so and so. Issue notice on interim prayer as well as returnable by 4 weeks. Learned Counsel will respond to obtain up-to-date instruction by the returnable date on which date the interim prayer shall be considered. List this matter so and so. Any construction, now my lord, any concern in respect of package concern if undertaken shall be without prejudice to right of the petitioner to claim compensation. Now the problem here is that my land, our whole instruction is that my land has been acquired. That 50 square kilometer has been acquired. Now full swing the work is going on. Now the only problem here, if they, because they will not be able to assess the Jirat. Okay, my lord, so far compensation tomorrow, if the writ petition allowed, so then I will get the area which they have acquired. But what about my Jirat? Jirat I will not get if they are going on full swing. That's why on the last occasion, on 5/2/2026, your Lordship reading the order of 5/2, they want to know the up-to-date instruction regarding status of the work. That is what the court has asked.
What work is going on?
This is the highway, my lord. This is construction of cutting of trees, my cardamom and everything, which I have built up. They are cutting that. That's the whole problem. All photographs are there, my lord. That's why the court has said, I projected the matter before the court that we are worried of that. Tomorrow, my lord, how will assess?
Yes.
They cannot assess. Court said, yes, your prayer is reasonable. Let us ask the government advocate. What is the status of the work? Whether the work is going or not. This is the only worriness, my lord.
Whether any direction.
No, they up to date status, my lord, report, my learned friend will be able to know.
Verbal instruction here. The work is going on.
This is the only problem. That's the whole issue, my lord.
Why verbal instruction?
So far written.
Why he let him take instruction, I have no problem, my lord. But this work should not go on, my lord. How will be calculated? That was the problem. Last time also pointed out, court said, okay, they will take update status of the work.
1 month have passed.
1 month has passed, my lord, and I have all the photographs, cardamom, my lord, trees, orange, everything is there, my lord. That's the whole problem. My lord, so far as the land is concerned, of course, my lord. Tomorrow also, if it is established, I'll get it. There is no problem. And Lordship will kindly see, they are saying proposed reserve forest. It is not also reserve forest under section 17 because there is a judgment of this court saying that even it is proposed reserve forest, it is not a reserve forest. This is the judgment which is passed by this court, my lord. Latest judgment, my lord.
This would require an expeditious hearing, entire matter.
Yes.
So what is your prayer?
No, my prayer, absolutely, he has to file an affidavit. My only prayer before this court, my area only. Let them go ahead. My area where I have planted Zirat, where I have planted orange, cardamom, it is going on. What I will get, your lordship will... Nothing I will get, my lord. What I will get? Land, no problem, my lord. That's why they said the order which is passed by this court, he said, what it said, my lord, and this said that if under a shall be without prejudice. But 5/2/2026, my lord, kindly see the order of 5/2/2026. See the order of 5/2/2026.
5/2.
Doing the work.
See that 5/2/2026. See 5/2/2000. They'll update instruction with regard to status of the work. Now, my learned friend is saying verbal instruction, yes.
No,
At one point of time, my lord, they have stopped at one point of time. This is your lordship will find at page 430. Kindly see at 430, my lord.
Page number
430.
What is there?
430, see the 430, my lord. This is also impugned, my lord. 430. This is 8th of October 2025.
What is this?
See, my lord, DC has written to General Manager. In further reference, VC under the chairman's advisor in presence of Learned Chief Secretary of Arunachal review the construction of so and so. Learned Chief Secretary has directed to resume the construction of the above highways earlier. Therefore, in this regard, SP Lohit shall visit the proposed site on so to inspect the resuming of the construction work above stretch of frontier highway by executing agency. This is for your information. This has also been put to challenge. My whole case is that you cannot do the work without any notification for acquisition of the land. You cannot say it is a proposed reserve forest. Under the law, proposed reserve forest doesn't become a reserve forest under section 17 of the Assam Forest Regulation Act. That is what the judgment has been pronounced by this court. Please see this. And that entire thing has been set aside. You cannot say that.
No, is it their plea that the acquisition order notification has not been made because of
They
the
said
fact that it is within the proposed reserve?
proposed reserve forest.
Okay.
This is our whole case. Please see this judgment, latest judgment in 2023. Same, my lord, proposed reserve forest. Ultimately, this was put to challenge, and they said that you can't do it. Proposed reserve forest doesn't become a reserve forest unless all the procedure of the Assam Forest Regulation Act is being followed. Please see the judgment of this court. So how can you start the work without any formal notification? See that, my lord. Page 31. See, operative, there are many parties. Page 31. That's all.
Page or para?
314. There are a lot of parties. The order starts from 16/6/2023. At page 31. The order 16/6/2023.
Yes.
See that para 20. Para 20. Operative portion.
Yes.
In the result, I find sufficient merit in a petition according the same stance allowed, granting following relief, impugned final notification dated 18/10/1980 stand quest for being issued without following the procedure prescribed under the Assam Forest Regulation. Consequently, the land covered by preliminary notification under Section 5 of the Assam Forest Regulation cannot be treated as reserve forest as no final notification in respect to the same was issued. The eviction notice for violation and so issued a pedestrian quash for being issued without any authority of law. Now, so far as 2 is concerned, 2 of the finding, Roman 2. Now, please see the petition at page 86. Page 86 to connect that whether it is the same subject or not. See page 86, my lord. Type copy is 87. Page 86. 87 is a type copy. See this. In exercise of power, this is 13 of December 1977. Please mark. This is the one of proposed reserve forest, 19 December 1977. Now, this judgment is of my lord, this is 1980, whereby under Section 5. Here is 1977. See, in exercise of power conferred by Section 5, same, under the Forest Regulation 1891, read with Section 3 of so and so, as adopted and modified by Northeastern Area so and so, Governor is hereby pleased to declare it is proposed to constitute the land described, that is a schedule herein annex, as a reserve forest, and to appoint the Deputy Commissioner Lohit Teju to be the forest settlement officer to inquire into and determine the existing nature, extent of any right claim or alias to exist in favor of any person of any right claim by or alias to exist in favor of any person in or ever any land comprised within the limits described the said schedule.
So it is a preliminary notification under Section 5.
Yes. That's what. So preliminary notification.
Under what provision the final notification is?
Under the Section 17 of the Assam Forest Regulation. That's what 17 of the Assam Forest Regulation Act.
Okay. No such notification.
Now, please. Now, what we have done, I know that question will come to your lordship. We made an RTI. I know that question will come to any of the court. Any of the court. I told my client, please give me where you are saying. Please see this notification. If I Notification, kindly see.
Yes.
There are yes. Please see 16th of February first. With referring to the your application, furnish the following information. Lordship got it?
Yes,
16 February 2025.
yes.
See number two. Number two, final notification under section 17, Assam Forest Regulation 1891. Whether a final notification under section 17 of the Assam Forest Regulation 89 has been issued in respect of Dalai proposed reserve forest or not. If yes, furnish the notification number, date and gazette, public and detail. Data not available. Kindly see that. Second, now second RTI, kindly see my lord. This is 28th of February 2026. Directly they have said not issued. Kindly see second RTI. Kindly see number 2. Final notification under section 17. Whether a final notification under 17 has been issued in respect of Dalai proposed reserve forest. If yes, furnish the notification number, date, not issued. If you are not issued, how can you acquire my land? So how can you acquire my land? So how can you work, my lord? That's our case. So your lordship will hear. Let them file. But they should not proceed. It is government won't say that it is not been filed. And that is a judgment of this court says that you cannot. You have to follow the procedure to declare as a reserve forest. Themselves they have stated it has not been issued. This is what the court on 5/2/2026 has said. What is the status? That is what the question concern about the court. If they finished the entire, my lord, by cutting, uprooting the entire, what I will get, my lord?
Now whether that cutting has been over or
No, it is going on. It is still going on. That's why whatever is left, at least whatever. They said that number of trees, cardamom, everything is there, oranges.
no, the question is
So what I am submitting before this court, let the survey be made. We will be present. Let the government be also present. In the meantime, a status quo should be maintained in respect of, kindly see. See all these photographs, my lord.
no halt to the.
No, that's why I'm saying, whatever they are doing it very well. But unless this is not being verified, this is not been done by them, well, how come, my lord, it will not be possible? Is it will be possible?
This gravel road.
Yes. Let them continue with the gravel road, but my land, where they are going on, this is,
Where is your land?
yes, these are my land, entire forest, my lord. That your lordship knows in Arunachal Pradesh, my lord. This is our land. These are belongs to clan.
Now what do you want?
I just want one thing, my lord. I want one thing. I don't want that particulars, it comes to come to a standstill. I know. Let them work. It's not that they cannot work. But my area, which you are constructing, that at least they will, in presence of my clan and their particular representative, they should come and they should assess.
What assessment?
The Jirat, whatever the trees, survey they should make it. If it doesn't make survey, then what I'll get, my lord?
Yes, ultimately.
I think making a reasonable prayer, my lord.
What is your submission?
Again, they can restart the work. There is no problem. Take it 1 week, my lord. 1 week or 2 weeks, they can do it, survey. And to this, they can do it. 1 week, 2 weeks will not make any difference, my lord.
No halt to the ongoing project. Only they will.
But suppose tomorrow your court lordship comes to a finding. Let's say that your lordship is satisfied. One, that without acquiring the land, you cannot say that it is a proposed reserve forest. That's why you are not entitled to get compensation. Proposed reserve forest doesn't mean that it is a reserve forest. This is being put to challenge, my lord. These are being put to challenge. This is package number 3, my lord.
What will be the ultimate relief?
Ultimately, relief what? They have to set aside, and if that be the case, then what a fresh notice for acquisition.
Yes.
So everything will go here, my lord. If they start, finish, then nothing remains. Court said that what will adjudicate the matter?
No, if
Academic,
ultimately, if it is found that land was yours and on your land, that highway is being.
my lord, there are certain provision under the Lara Act that if it is an urgency matter, yes, you can acquire. Under section 40, you can acquire under section 40. Even without acquisition also that you can acquire, but 42 says that 80% has to be given.
Yes.
This is your lordship is aware, this is under 40. Parameter which is under earlier is 17.
Yes.
Earlier it is 17. This is urgency. This is an urgency clause, my lord. But what I have been told that so far package 1 and 2 there is some notification. Package 1 and 2. One is notification. Yes, there was notification in package number 1 also for acquiring the land. So, my lord, today what happens? Suppose your lordship finds that propose it is you cannot declare the reserve as a reserve forest because proposed reserve forest section 5
No,
will.
that point is clear.
Yes.
That is okay.
Then
Now what?
different cases, then how can you proceed with the work? You cannot proceed. There has to be a notification under the Lara Act.
No, but finally to come to the conclusion, a detailed hearing.
Then detailed hearing, your lordship. Then all this circular, they said that this is the under the.
We can do one thing. We can fix it for hearing at a very short date. In the interim, do you want any relief?
I just want one submission that they will not do anything so far as my land is concerned until and until the Jirat is not been completed. Jirat, that they have to work out. Otherwise, what I will get, my lord, tomorrow everything is, that's the reason on 5th of February 2026 that order was passed. My respectful submission is that let them do a survey work. Let them survey it, my lord. My men will be there, all the claims will be there, their state government will be there, my learned friend's client has to be there. All three will be present. Let them survey it.
No, but the photographs which you have shown.
Yes.
Already shows that there is a road.
No, that road, no, that is one passage. They have to make a huge road, my lord.
Okay, highway.
That, yes, highway.
Yes. What is your submission?
My lord.
You were asked to produce the up-to-date status.
Yeah, and if your lordship kindly see.
My lord. I am for respondent number 7 and executing agency, my lord.
Who is respondent number 7?
Executing agency, my lord.
NHIDCL.
Yes.
You are appearing. Yes, 316.
Yes, state government.
Please, 1 second, before my learned friend, one last submission I want to point out before this court. See at page 316. See, my lord, see at page 316, at last paragraph, that this is
What is this 316?
yeah, this is a minutes of meeting on 24th of July 2025.
Yes.
Now see at page 316.
Yes.
The DFO, Lohit, Lordship Lohit,
Yes.
Lohit clarified about the issue of Dalai proposed reserve forest. He stated Dalai reserve forest is proposed one without final notification, but it is as good as reserve forest. My lord, they are going on that premise. How can it be as good as reserve forest, my lord?
No, in this case, the pleadings are complete.
Yes.
You have submitted your affidavit in opposition.
Yes.
Is it your stand that because of the fact that the land in question falls within proposed reserve forest, acquisition notification could not be issued. Land could not be.
Yes.
Is it your stand?
Yes.
Okay, that is to be decided in this case.
Yes, right. But they should, my lord, tomorrow if they find that this is not a proposed reserve forest, cannot be a reserve forest, end of the matter, how can they proceed without a notification? Then how can they go ahead? And then tomorrow it comes, it's academic, only is a matter of academic discussion only. Will not, Mr. Das will not go into all this aspect of the matter. That's the only difficulty, my lord, which we are facing. So I will not get anything tomorrow. What I will get?
No, ultimately assuming that your writ petition is found that you have a case and your land has been used without any notification regarding acquisition of the land.
Very well.
Then what relief you will?
What I will get? Relief I will get only on the basis of land. Under section 26 to under Lara Act. Only that I will get it.
No.
Not beyond that.
No, whether the fresh acquisition notification has to be passed.
Of course. If, my lord, if this goes, then fresh notification has to be passed.
And at that rate which is prevalent at the time of fresh notification.
My lord, there are few things in this case. If it is a clan, or a
Now
community
your
land,
concern is that though you may get the price for land,
but
you may not get the price for Jirat
yes,
because of the
I will not get.
difficulty in assessment of the.
Correct. Absolutely. That's my concern. What will remain? At least, my lord, till the hearing is being concluded, at least that part, my lord, they will not go ahead. They have to do a survey, my lord. This is not the way, my lord. I think it's a very logical, it's a very reasonable player I am making, my
Who
lord.
will do survey? NHADCL.
But along with our people has to be there, my lord. DC has to be there. Committee has to be formed. At one point of time, I
How
also
much land do you have there? How many petitioners are there?
576.
Oh,
It is that's why a clan. 177. 177, my lord.
so
These are all clans. Different clans. This is a huge, my lord. That's why I'm saying all in state of Arunachal Pradesh, what we have done land acquisition, either is a community land or is a clan. It is backed by Lara Act. It is backed by RRR Policy Act, Rehabilitation and Resettlement Policy 2008.
And what is the basis of your claiming ownership over that land?
My basis, my lord, it is on the record. It is on record that it's a land which ancestor land. There are certain documents to show that we have been using. Like gun license we have got. Census 2011 or 2019.
No, gun license will not help.
No, there are census. 1961, 71, 1981 and 2011. Census.
Showing that you are a
Yes.
resident of.
Yes, right. Of that village.
And your right over land accrues from. what?
Ancestral land is a clan. My lord, all in state of Arunachal is a community land or is a clan land or there were a private lands. If it is a private land, then it is under Lara Act. If it is a community and clan land, then land is to be assessed as manual 2022. Plus, they are entitled to get under RR Policy Act 1908.
Yes.
So these are the provision which has been laid down. So now tomorrow the only anxiety, what I will get from Jirat, my lord, not a single penny.
No, if you can satisfy that this was like photographs or other evidence
Yes.
that this is the loss which has been caused to you.
No, that will be of a bit of very difficult to show, my lord, that what loss I sustain, this is a loss. It is only by way of going and survey and assessing. There may be hundreds of orange trees, my lord.
Now, how much land is involved?
Iman,
Because
what is the land?
number of petitioners are
Yes.
also It may not be a survey is also
ये वाला जो minutes meeting है।
356.9
acres.
Hectares.
Yes. This stand you have taken somewhere in the writ petition.
Yes, yes.
How much land
Yes.
is involved?
Yes.
Is there any difficulty on your part to conduct a survey?
No, Milan. Without stopping the work, that can be done, Milan.
Yeah, sure. So without stopping the work, the survey can be done. That's possible. Yeah.
Without stopping the work, nothing remains. Nothing remains in the case. Let's suppose tomorrow, if your lordship find that these all the decision which they have taken by way circular, proposed reserve forest, no acquisition, nothing is to be paid. Tomorrow, if the court finds on merit,
No, when can it be listed for hearing?
let it be on 6th then, on 6th of this month. 6th. But there is some more interim order can be passed on 6th. Well, otherwise nothing will remain in this case, my lord.
Are you ready? Is it okay for you?
Yes, Milan.
Okay. Then we are fixing it on 6th.
6th.
Today will not pass any orders.
But on 6th and my statement, this urgency is there, that's why.
Third, Mr. D. Das, learned senior counsel, assisted by Mr. I. Chaudhary.
I Das.
I. Das, learned counsel for the petitioners. Also heard Mr.
Why?
Ram, learned government counsel, appearing for respondent number 1 to 6, as well as
RB Yadav.
Mr. R.B. Yadav, appearing for NHIDCL.
7 and
That is respondent number 7 and 8. Due to paucity of time, this matter could not be taken up for hearing today. Stop. Learned counsel for the learned senior counsel for the petitioner has submitted that in this writ petition, the petitioners have approached this court being aggrieved by utilization of their land for construction of only Ayuliang within bracket package 3 KM 00002 KM 121 500 length within bracket length 61.500 km of the frontier highway in Lohit district without formally acquiring their land.
Yes.
He submits that the contention of the respondent authority is that since the land over which the petitioners are claiming their right falls within proposed Dilai Reserve Forest, no notification under Land Acquisition Act would be issued. However, learned counsel, senior counsel for the petitioner submit that the petitioners have been informed on an RTI application filed by them that no final notification under section 17 of the Assam Forest Regulation Act, Assam Forest Regulation 1891 has been issued in respect of Delhi proposed reserve forest, and therefore he further submits that a coordinate bench of this court has, in the case of Shri Masong Pada and 154 others, within bracket WPC 290/2014, has held that if a land is covered under preliminary notification under Section 55
Section 5.
of the Assam Regulation Act, and no final notification under Section 17 of the said regulation has been issued, the said land cannot be treated as a reserve forest. Hence, he submits that the plea of the respondent authorities is not sustainable. He submits that there is every possibility that in this writ petition, the petitioner would get a favorable order. However, he submits that in the meanwhile, if the construction of the highway, frontier highway, continues without any assessment of the damage to the Jirat over the land of the petitioners land of the petitioner continues. Ultimately, in the event of a favorable order by this court in the writ petition, there may not be any basis for assessing the loss suffered by the petitioners on account of loss to the Jirat. Hence, he submits that a survey of the land of the petitioners is of urgent necessity in the instant case.
Till then, no, but your lordship can fix on next date.
So,
Till that, this is my submission. That
he also submits that considering the concern shown by the petitioners, the further construction work of phase 3 of the frontier
package
highway,
3, package 3.
sorry, package 3 of the frontier highway in Lohit district may be stayed. After considering the submissions made by, now on the other hand, learned counsel for the respondents submits that they are agreeable to the proposal of a survey made in the survey made regarding the land claimed by the petitioners. However, they are opposed to any stay granted to the continuation of the construction work of the frontier highway in Lohit district in the meanwhile. Stop. After considering the submissions made by learned counsel from both sides, this court is of considered opinion that this matter is required to be heard on urgent basis. Accordingly, let this matter be listed for hearing on 6th of March.
Yes. As on admission, well, on admission column.
In admission column.
And if the admission here is not that the interim, my interim prayer should be considered on that date. If
No.
that is not taken up.
If I reflect that, it would give an indication.
No, only I'm saying that, I'm not saying the interim order to be passed. That if admission hearing doesn't take, hearing means full hearing. Then if doesn't, then paucity of time, well, my interim prayer may be considered, because your lordship today has heard. Interim prayer may be considered on next day.
Whatever I have reflected,
Yes,
that is enough to,
that's all.
for you to press
Yes.
for any interim relief on that
Fine, my lord, fine.
list accordingly.
I'm deeply obliged, my lord.
Item number 14 and 15.
We have to only issue notice.
Yes, yes. Malad has heard my senior Malad, Mr. Sharma, was through VC.
14 and
14 and 15.
I have 55 and in 15, I have 59, Malad.
This is coming for the first time.
Yes, yes.
14. This interlocutory heard Mr. R. Sharma, assisted by Mr. R. Dubey, learned counsel for the applicants. Also heard Mr. Who is appearing?
I'm,
My lord, I am for the respondent number 1, my lord. At least contempt number
Mr.
in IA, I am for the opposite party, my lord. In both IA, my lord.
Just a minute. Mr. L. Kato,
Yes, my lord.
learned senior government advocate,
No, my lord.
learned additional AG.
DSG, my lord.
Oh, sorry.
Malad, in, Malad, may I clarify? In I, Malad, we have made only the petitioner a party.
My lord.
As a opposite party. Because
Who
we
is the
want to
petitioner?
Me, my lord. I am in both IA, I am for the opposite party, my lord. Yeah, and
What is your prayer here?
Malad, here we want to delete our name because there is no direction as against.
You are one of the respondent.
Yes.
One of the contempt.
Yes, yes. 4 and 5.
so I pray some time, my lord, to file appropriate response to his IA, my lord. In IA,
In I Likhivo, heard so and so. Also heard Mr. L. Perme, learned counsel for the opposite party. This interlocutory application has been filed by the petitioner has been filed by the applicant Vipin Kumar, who has been made as contender number 4 in the connected contempt case number 1 of 2026. Learned counsel for the applicant petitioner submits that since no direction was passed by the court in which case WPC number?
Malad, 445 AP of 2024. It's a common judgment, 17/9/2025. But the contempt they have filed in WPC 445.
In WPC 445/2024 against the present petitioner. Hence, then name may be struck out from the connected contempt case. On the other hand, Mr. L. Perme, learned counsel for the respondent / applicant in the contempt case, bracket close, prays for some time for filing a written objection against the prayer made by the applicant. The prayer is allowed. Let this matter be listed
Can it be on 16th, Malad?
on 16th of March. And what is the status in the contempt case?
But there is the other I is also there, Malad. Same. The only respondent name is changed, Malad. Applicant 59.
Only IAs are listed today.
Yes, yes.
Other IA.
59. Only the name will change and respondent number 5.
Same order.
Yes.
Applicant instead of
Vipin Kumar, he would be Ajay Kumar Kapoor.
Instead of Vipin Kumar, it will be Ajay Kumar Kapoor. Other things remain same. List accordingly on 16.
Malad,
Your
item
Lordship.
number 15. The
Yes.
main content, Malad. I am for the respondent number 1, Malad.
In fact,
Item number,
because of listing of the I only, the contempt has been listed along only.
so we'll not pass any orders in contempt today.
Well.
On 16th, we'll see.
Deep delve.
Okay. Deep delve.
Item number 10.
Lordship, this contempt petition is directed against non-compliance of this honorable court's judgment and order, whereby alleged contemner has been directed to deposit the compensation amount. That they are yet to deposit the amount, Your Lordship.
What is your stand?
Malad, my instruction is, Malad, after the receipt of the Malad, the order passed by the Honorable Court, Malad, accordingly we proceeded, Malad, for the final assessment, Malad. Thereafter, Malad, the assessment was done and by the Deputy Commissioner. Malad, it is not simply, Malad, given a directions for payment, Malad. Amount has to be ascertained, Malad,
It is
calculated.
a land acquisition matter.
Malad.
Is it
Correct,
land
sir.
acquisition matter?
Correct, yes, sir.
Correct.
Okay.
Thereafter, Malad, even matter was pursued with the Deputy Commissioner, who is the acquisition authority, Malad. And Malad, we approached the Malad Deputy Commissioners for final Malad assessment and Malad the fixing of the Malad the amount. But that several correspondence were made, Malad. But Malad, 15 December 2025, Malad amount has been. We have written a letter to the Malad Deputy Commissioner for fixation of the amount to the tune of Malad 2 crore 26 lakhs 50,488, Malad. And Malad, it is still pending with the Deputy Commissioner, Malad. Once the Malad, the all Malad, the correspondence and Malad, the fixation of this amount is received, Malad, will proceed and we are ready to pay, Malad. We are not denying, Malad. Only thing is that, Malad, the amount has to be, Malad, ascertained, Malad. How much amount is liable to be paid. But in the order passed by this Honorable Court, which is supposed to be, Malad, complied with, is also not specific, Malad. If Lordship peruse the Malad order passed by this Honorable Court.
No. Have you filed any written reply
Yes, Malad.
taking this stand?
Yes, Malad.
No, but it is, the direction was to you. So in event of non-compliance, it is you who will have to face the contempt.
Malad, if Lordship
So-
perused, Malad, if Lordship perused the Malad order passed by this Honorable Court, by Malad, which is supposed to be Malad complied with, is Malad at page number 34, Malad. It is not, Malad, as simple as, Malad, the direction has been given for payment of Malad. It is something, Malad, so where, Malad, the amount has to be extracted, Malad. Because of that reason, Malad, we are, Malad, also not able to comply with, Malad. It is, Malad, directly linked with the Malad Deputy Commissioner. How much amount has to be released, Malad, is, Malad, has to be.
Deputy Commissioner was also the contemner here.
No, Lordship,
No,
we have not made him as a contempt.
It is the Deputy Commissioner who has to finalize the amount, Malad. Malad, in view of the above, direction is passed by this Honorable Court, this court, by judgment and order dated 6/12/2023 in WA number Malad 40 of 2022 as extracted herein above, shall also cover the issue arising in the present proceedings. Consequently, the respondent authorities are directed to authorize the petitioners herein with due compensations for the cardamom crop standings on their respective lands in accordance with the directions passed by this Honorable Court, by this court, by order dated 8 September 2022 in WPC number 320/2021, and upheld this upheld by this court by judgment and order dated so and so in WPC, WA number so and so. My lord, so therefore, my lord, amount is not yet a certain, my lord. My lord, correspondence are being made with the deputy commissioner and the department. Still, my lord, that is not yet finalized. Because of that reason, my lord, the amounts are not being, my lord, released to them, my lord. Once, my lord, everything is clear, every, my lord, the figure, the amount is a certain, my lord, we are ready to pay, my lord.
Yes.
Lordship, this contention has been for the last 1 year, Lordship. Their contention, Lordship.
No, you have not made DC a party.
Lordship, DC, they have forwarded the amount, Lordship. Demand note has already been sought from the DC side, Lordship. That particular, they are not depositing the amount, Lordship.
Where is that demand?
Lordship will kindly come to page 95 of my contempt petition, Lordship. This is of 29 November 2024, Lordship. This is the demand note served upon officer commanding, Lordship. The amount has been clearly mentioned. Bank account detail has already been served, Lordship, already been given.
4948.
Lordship.
Is this the amount?
Now they say that this is not the exact amount, Lordship. So why certain, so many communications are happening between both the deputy commissioner and the officer
The
commanding.
court has not given any indication.
Lordship, in that particular judgment and order, the court has relied upon similar situated kind of a case, which was disposed of by this honorable court. In fact, the matter was taken up before the division bench also, Lordship. There, the same issue, Lordship. Now here, issue involved was, Lordship, in regards to the rate of the cardamom, Lordship, fruiting and non-fruiting. Initially, the assessment that was conducted, the amount was more. It was around 2,000 for fruiting for cardamom, Lordship. Now that was reduced to 1,000 rupees, Lordship. And for fruiting, it was 1,000 rupees and it was reduced to 500 rupees. That was put to challenge. That reduced order that was passed by the deputy commissioner, reducing that rate of that particular this cardamom.
You put the same to challenge.
Yes, we put the same into challenge.
Before
Lordship.
the reference court.
No. Before this honorable court, Lordship. Before this honorable court. That particular order passed by the deputy commissioner was set aside, quashed, and the initial assessment that was conducted, that was confirmed. So the amount that was supposed to be, the exact amount was around 4 crore, Lordship. The half of the amount was already paid, but half of the amount was not paid. The half of the amount that was not paid is around 2 crore 26 lakhs, something like that. That has to be deposited by the...
Yes, Mr. Kato.
My lord.
This 29 November 2024 communication.
My lord, first demand note was sent on in the month of, my lord, 29 November 2024, my lord. The figure was again different, my lord. And again, my lord, second demand note was sent on 5th June 2025, my lord. There also, my lord, the figure was not correct, my lord. It was, the figure was mentioned sometime 3 crores, sometime 2 crore, sometime, my lord, more than 3 crores and above, my lord. And third demand note was, my lord, sent on 1st July 2025, my lord. Thereafter, my lord, again, fourth demand note was sent on 1st August 2025, my lord. And the figure was 2 crore 87 lakhs 42,987, my lord. Now, my lord, for finalization of the, my lord, figure, this letter has been sent to the, my lord, the again deputy commissioner by mentioning the correct figure, my lord. But my lord, we are also, my lord, unable to, my lord, explain why the deputy commissioner is not finalizing the amount, my lord. Once it is demand note, everything is finalized, my lord. Malad, we are not saying that, Malad, we are not going to pay any amount to the petitioner. We are ready to pay, provided that please kindly ascertain the, Malad, the amount, which amount has to be exactly, which exact amount has to be paid to the petitioner is not yet ascertained, Malad, as of now, Malad, by this letter, Malad. If Lordship see, this was sent on 15 December 2025 to the Deputy Commissioner, Madam Anjo, Hawaii. Charge expense sanction amounting to Rs 2 crore. It has been reduced again. 2 crore 26.
No, then you should have made Deputy Commissioner as a part.
Correct, madam. Deputy Commissioner is not giving furnishing the correct figure, madam.
He is giving different figures.
Sometimes, Malad, including those petitioners who are not involved in this, Malad, the main writ petition. Sometimes, Malad, they are giving the Malad the numbers of Malad petitioners. So therefore, Malad, only because of the Malad, the difficulties on the part of the respondent authorities, the Deputy Commissioner is Malad sitting over the Malad the issue.
Yes, what is to be done?
Lordship, this communication letter.
You implead Deputy Commissioner as contemptor in this case.
Lordship, but that may be allowed, Lordship.
Yes.
I'll implead him.
Heard Mr.
J. Ginny, Lordship.
J. Ginny, Learned Counsel for the, this is item number 10.
10, Lordship.
J. Ginny, Learned Counsel for Learned Counsel for the petitioner. Also heard Mr. M. Kato, Learned Deputy Solicitor General of India. Who submits that the Union of India. You are representing Union of India, no?
Malad, by name, they
who is the
alleged contemptor is Malad, the earlier commanding officer, Malad, the P. Ankus. Malad, now he has been transferred to some other place. One new officer has been Malad included as respondent number 2, Malad.
who submits that contempt number and number 2?
Abhay Pratap Singh.
Abhay Negi, Malad.
You are representing both.
Both, Malad.
Abhay Pratap Singh.
The present contemptors. The contemptors in the instant contempt petition are ready to comply with the direction of the court passed in WPC number 291 within bracket AP/2022. Number is okay.
Correct.
2022. However, he submits that the for paying the compensation to present petitioners in terms of the direction passed in the aforesaid writ petition, the Deputy Commissioner has to assess the compensation amount and submit the demand for disbursement of funds to the present contemptors. He, however, submits that Deputy Commissioner Anjao District, Hawaii, has on 3 different occasions raised demand for
4 occasions.
On 4 different occasions raised demands for different sum of money. What was the last? Where is your letter where you have mentioned?
My lord, lowest documents which I produced before your lordship is of my lord 15 December to 2025, my lord. The earlier my lord demand note, my lord, on 4 occasions, my lord, it was on first occasion on 29 November 2024.
Where is the mention
My lord, in fact, yes, it is not mentioned in this my lord, close sheet, my lord.
He submits that on the first occasion, the Deputy Commissioner, Anjo District, had made a demand for rupees 3 crore 49 lakh 48,312 by its letter dated 29 November 2024, addressed to the contemner number 1.
No, my lord, to the Deputy Commissioner, my lord. Addressed to the Deputy Commissioner.
No. Deputy Commissioner addressed that letter to you.
29 November.
This is a letter of Deputy Commissioner
Yes, my lord.
addressed to contemner number 1.
Correct.
However, later on, which is the second letter?
Second letter.
My lord, on 5th June 2025, my lord. Second demand note.
However, on 5th June 2025, a second demand note was issued by the Deputy Commissioner Anjo with an amount of
3 crore 6 lakhs 4,229, my lord.
Likha. Thereafter, the third demand note was issued on
1st July 2025.
for an amount of
3 crore 8 lakhs 58,815, my lord.
thereafter on the last occasion, that
On
is
4th, my lord, 1st August 0108 2025 for
1st of August 2025.
25 for an amount of 2 crore 87 lakhs 42,987. And my lord, this lose my lord last and final is my lord.
이다 놓고 난 거냐?
2 crore 26 lakhs 50,488 is sought for, my lord.
Where is that?
Well, the documents which I have put in is the last correspondence made to the my lord, Deputy Commissioner for fixing the amount to that my lord, to the tune of my lord, 2 crore 26 lakhs 50,000.
No, in the last
demand note, man.
In last document, it is not a demand note.
This is not a. It's a communication letter.
And 15 December 2025 is the my lord, the letter for clarification in response to the my lord, the earlier letter dated 28 October 2025, my lord. So therefore, my lord, my lord, it seems the matter is still pending with the Deputy Commissioner, my lord. He is not, my lord, communicating, my lord. And also, we are also, my lord, the surprised why Deputy Commissioner is not finalizing the amount, my lord. Every time, my lord, keep on sending the my lord, demand note with different figures, my lord. That is the whole difficulty, my lord. We are not in a position to comply with.
Learned, stop. What was the last line? Was demanded. Stop. Learned Deputy Solicitor General of India has submitted that as
Lordship, I think we have one more this in panel with one more demand note from the Deputy Commissioner dated 3 November 2025.
give it to me.
This has
I think
already
this
been passed, my lord.
this amount is the correct amount. As per our calculation also, this is the correct amount. Lord.
Okay, nice. Took responsibility. Now it is pending with the deputy clerk.
226.
Yes, correct, Lordship. 226.
Is
2
there
crore
any
26.
mention, Abhishek, whether demand notice dated 3/11/2025 has been mentioned?
I think it is not there, Lordship. Hmm. 29 November also.
29 November to the, it was the first, my lord. The
First one is 29 November 2025. That is the first one. Last one is the
last line. Dekho.
1 August.
Learned DSJY, the Deputy Solicitor General of India, has further submitted that on 3/11/2025, the Deputy Commissioner Anjaur District has again submitted demand note for rupees 2,26,50,488 for complying with the order of this court passed in WPC number 291 within bracket AP/2022. Stop. Learned Counsel for the Learned GI has submitted that since different amounts were demanded by the Deputy Commissioner on different dates, hence some clarification was raised by the AE within bracket civil, comma, second in command. (116) Road CC within bracket grave to the within bracket grave JREF loose sheet to the Deputy Commissioner Anjaur seeking certain clarification from the Deputy Commissioner. However, the said clarifications were yet to be made by the Deputy Commissioner, and hence, though the containers are ready to comply with the order of this court, it is unable to abide by the order passed by this court. He also submits that under such circumstances, the presence of Deputy Commissioner Anjo, District, Hawaii, in this contempt case would be necessary. Considering the submissions made by Learned Counsel for the Learned DS, the Deputy Solicitor General of India, let the present Deputy Commissioner of Anjo District be impleaded as respondent number 3 in this contempt petition, and let notices be issued to him. The petitioner shall take steps for submitting a amended cause title in the instant contempt petition, as well as also take steps for issuance of notice to the incumbent Deputy Commissioner of Anjo District. You have to find out name.
Name, I'll find
will.
out, Lordship. Accordingly, I will file the application for impeachment.
Yes. Let this matter be listed after 2 weeks.
Well, 2 weeks.
On a date to be fixed.
Well, deeply obliged, Lord. Well, I'll be in need of that loose seat, my lord.
No, you take it back.
Yes.
This in another case.